Okay, good morning, everyone, and welcome to Courtroom 1. This is the case of People versus Avery Becker. I'm Judge Jim Miller. I will be presiding in the case, and want to, first of all, thank all of you for your hard work and your doubly hard work in this video environment. I'm going to be assured in advance that you've all done a great job. What I'd like to do is go through the presiding judge pretrial checklist here. Some of these things will obviously apply more or less in the video environment, but let's go through them just so I don't miss anything. Let me ask, is the prosecution ready for trial?
Yes, Your Honor.
All right. And is the defense ready for trial?
Yes, Your Honor.
Okay, thank you. I'm going to defer to the teams here because I know you've been through a couple of rounds. I'm to ask each side to provide the judge and the scoring panelists with copies of its trial roster with the team's code. And I believe we have teams G and Q, if I'm not mistaken. I understand that you've done that in the past via the posting those rosters in chat. Is that correct?
Yes, Your Honor.
And if everyone will do that, or if each team will do that, that would be great. And I see the prosecution's roster is up. Okay. Very good. And I think we need the defense roster. And there we go. Thank you. Now, of course, this is being live streamed, and what I'm going to read next probably applies more in the courtroom environment, but not necessarily. If anyone is recording the proceedings here, if video recorders are present and being used, whether where you are or via YouTube, both teams must have approved the taping of the round. Neither coaches nor gallery are permitted to tape the trials without permission. I need to inform everyone, gallery and Colorado Bar Association, or gallery members as well as the teams rather, that the Colorado Bar Association may be taking photographs of the competition, well, not necessarily, but maybe capturing screenshots or whatever during the round. And by your participation in these in the state tournament, you're implicitly granting automatic permission and the use of these photos by the Colorado Bar Association. You guys all look great on camera anyway. Is anyone, excuse me for just 1 second. And I'll remind anyone watching the live streams on video, because I don't know who has access to that student members and coaches of other schools or of the same school but of a different team may not be observing this round unless specific exceptions apply. And if they do, let me know, or let the administrator know. I need to remind the teams that no recesses will be allowed with the exception of those granted for a health emergency, and especially not between the end of witness examination and the beginning of closing arguments. I need to ask the scoring panelists at this point if any of you have reason to believe that you might be biased in judging either team. Do the scoring panelists have any concerns in that regard? I believe that's Mr. Bockenstedt, Ms. Lindsay, and Ms. Rogers. Any concerns about your ability to be impartial in your duties here?
Sure. None from me, Judge. Thank you.
Great, thank you. And I'll take silence as well as an affirmation there. I need to remind the teams and the coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. I need to remind the teams that your compliance, excuse me, with time requirements will be considered in scoring individual performances. I would ordinarily confirm that no coach or team member was seated in the jury box. Are any of you online here in a room with coaches or team members? Okay, just more out of curiosity, I suppose. And with this, can I ask first the prosecution to introduce its team members?
Yes, Your Honor. Good morning, Your Honor, members of the jury and opposing counsel. My name is Emma Senishin. If my co-counsel could go ahead and introduce themselves.
Absolutely, thank you.
Good morning, Your Honor. My name is Alexandra May.
Good morning, Your Honor. My name is Lily Humber. May our witnesses introduce themselves?
Please.
Good morning, Your Honor. My name is Carolyn Johnson, and I am Kyle Kuzak.
Good morning. My name is Tess Hayden, and I am Jordan Markowitz.
Good morning, Your Honor. My name is Lola Fakes, and I am Alex Cifuentes.
All right, thank you. And if the defense would do the same, please.
Your Honor, before we do our introductions, it seems like one of our team members got kicked and she can't get back in, and she needs somebody to let her in.
Okay. Were any of you given an emergency number of any kind to get back to the courtroom monitor? Okay. Why don't you advise, did you say her? And she may have done this already, log out and log in again. Just start completely from scratch.
Yes, Your Honor.
That seems to be the answer to about 90% of the problems on Zoom.
She said that she is going to try that, and it's telling her that the meeting host will let her in.
Okay.
So I don't know who that is, but
that should be the courtroom monitor. Let's give that just a couple of minutes and then just assure her, and I will assure all of you that we've all had to make huge adjustments. I'm a former county court judge, and I know that judges currently sitting on the bench have had to get used to online hearings, and what I do now is full-time mediation and arbitration, and we've had to make accommodations in many regards. So everybody just relax. Don't get excited. Don't panic when this happens. And I think we're good to go again. And I assure everybody you're not going to be judged in your performance based on the performance of the technology, so you don't need to worry too much about that. Do we have everybody?
yes, Your Honor.
Excellent, excellent. So, counsel, if the defense then would introduce its team.
Good afternoon, Your Honor, opposing counsel and members of the jury. My name is Kira Graham, and I will be conducting the opening statement, the direct examination of A.V. Becker, and the cross-examination of Kyle Kuzak. May my co-counsel now please introduce themselves?
Please.
Good afternoon, Your Honor, opposing counsel and members of the jury. My name is Liam Anderson, and I'll be conducting the direct examination of Professor Blake Van Owen and the cross-examination of Detective Jordan Markowitz.
Okay.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Caroline Dieter, and I will be conducting the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, and closing arguments. May our witnesses introduce themselves?
Yes, ma'am, please.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Emma Nicotra, and I am Blake Van Owen.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Macklin Gifford, and I am Taylor Perkins.
Mr. Perkins, thank you.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Juliana Martin, and I am Avery Becker.
Very good, thank you. And again, bear with me for just a moment here. All right, at this time, I'd like to administer the necessary oaths. And if I could have the team members only for just a moment, please raise your right hands. This excludes the witnesses. Team members, do you promise that the presentation you are about to give, excuse me, will faithfully and truthfully conform to the facts and rules of the mock trial competition? If so, say I will, or I do.
I do.
I will.
And
I
if
do.
thank you. And if the witnesses, please, would raise their right hands. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If so, say I do or I will.
I do.
I do.
Thank you.
I do, Your Honor.
And if the scoring panelists then would raise their right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? If so, say I will or I do, please.
I will.
Thank you.
I will.
And gallery members, including teachers and attorney coaches, family members, and friends, I'll ask each of you to commit to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round. And we certainly appreciate your support of these teams. With that, I think I've asked already, is the prosecution prepared to proceed?
Yes, Your Honor.
Any preliminary issues the prosecution would like to take up before we get to the evidence, and then I'll ask the defense the same.
Yes, Your Honor. We have 4 housekeeping matters.
Okay.
First, it seems as though the chat is disabled in that we only have the option to chat everyone or the host.
I don't know if I would suggest, counsel, that you chat the host and ask her to enable the private chat. My terminology may be a bit off, but I think that functionality is there. I think if you or someone would message her, I think it's her, I think they can enable that for you.
Thank you, Your Honor.
Okay.
We request to reserve any time not used in our closing argument for rebuttal.
All right.
Next, there are stipulated facts that have been agreed to before the trial today. We request that these stipulated facts are constructively read into the record.
Okay.
Third, Your Honor, when we enter exhibits during the trial today, we intend to screen share the exhibit at the onset of the questioning of the witness. We would then proceed with entering the exhibit. In this case, the jury would not constructively see the exhibit until it has formally been admitted by Your Honor. Would this be acceptable?
That's acceptable to me. Does the defense have any objection to that process?
No objection, Your Honor.
All right.
We have no further housekeeping matters at this time, Your Honor. Thank you.
And then for the defense, are you prepared to proceed, or do you have any preliminary issues of your own that you'd like to address?
Yes, we are prepared to proceed. I just have one housekeeping matter in addition to those already said.
Mr. Anderson, go ahead.
We request that if any technical issues arise for any of the attorneys or witnesses, that time may be stopped in order to give time to fix those.
Sure. And I assume there's no objection from the prosecution.
No objection.
Okay. And by the way, in that regard, who's keeping time? How are we keeping time here?
Your Honor, Ms. Bennett Spurlock will be timekeeping for the prosecution today.
And someone for the defense as well?
Yes, Mr. Abbott Howe will be our timekeeper, Your Honor.
Excellent. Thank you. Anything else then for the defense?
No, Your Honor, we're ready to proceed.
All right, if the prosecution would like to proceed with its opening statement, please.
Yes, Your Honor.
Ms. May. Go ahead, Ms. May.
Mischief was intended, in murder it ended. Good morning, Your Honor, members of the jury and opposing counsel. My name is Alexander May, and along with my co-counsel, Ms. Emma Senishin and Ms. Lillian Humber, we represent the state of Colorado. We are here today to provide a story, the story of March 6th, 2020, the day that Mr. Mackenzie Brackman's life was taken far too soon. Mr. Brackman was a mock trial coach at Colorado High School, volunteering his time in order to allow the children he coached to grow with their love for mock trial. Let me tell you a story, the story of Miss Avery Becker. It's 3 o'clock on a Thursday. Miss Becker is just getting home from school. In a fury, she throws down her backpack and storms into the kitchen with rage. You see, after participating in mock trial, putting in countless hours of work, and getting great results at competitions, her coach, Mr. Brackman, continues to belittle her efforts. He removed Miss Becker from the mock trial team. Miss Becker was furious. She climbed on the hood of his car and wrote in permanent marker, "Worst Attorney Award." But this wasn't enough. As she hid away the Sharpie marker, she texts her friend, Alex Cifuentes, in presenting her intent to break into Mr. Brackman's house and vandalize his belongings. Her eyes are tearful with anger. Avery's mom enters into the kitchen and asks what's wrong, to which the defendant responds, "I will get back at him if it is the last thing I do." The defense will call 3 witnesses to the stand today. They will call Mr. Taylor Perkins to the stand, the defendant's lifelong best friend, and only alibi for that day, who will show to you how loyal he is to Miss Becker and has gone to incredible lengths, including quitting mock trial in order to benefit the defendant. What else is he willing to do for her? They will call Mr. Blake Van Owen to the stand, an expert testifying in a field that she quit the job that directly relates to. And last, they will call the defendant, Miss Avery Becker, to the stand, who's had a history of problems with Mr. Brackman, who wasn't at school the day of the murder, who presented her intent to break into Mr. Brackman's house and vandalize it. That mischief was intended, but the way it ended was murder. The prosecution will also call 3 witnesses to the stand today. We will call Ms. Kyle Kuzak to the stand, an expert in crime scene reconstruction, who conducted a meticulous investigation. After conducting this investigation and collecting her evidence, created a timeline for the day of March 6, 2020. This timeline presented a perpetrator matching the height and build of the defendant, breaking into the house, and then proceeding to stab Mr. Brackman in the back with a knife. We will call Detective Jordan Markowitz to the stand, an expert in cell tower data analysis, who collected the cell tower records for this day that placed the defendant's phone directly pinging off a cell tower close to Mr. Brackman's house. And last, we will call Ms. Alex Cifuentes to the stand, a friend and teammate of Ms. Becker, who will testify to receiving texts expressing the defendant's intent to break into Mr. Brackman's house. Ms. Cifuentes will also testify to the tension and issues between the defendant and Mr. Brackman. Your Honor, members of the jury, the prosecution holds the entire burden of proof today, but you will see that we have provided mountains of evidence in order for you to rule in favor of the prosecution. At the end of the trial here today, my co-counsel, Ms. Lillian Humber, will summarize the facts presented to you today, and you will see that there is no reason not to believe beyond a reasonable doubt that Ms. Avery Becker is guilty of second-degree burglary of a dwelling and murder in the first degree. As the trial proceeds today, I ask you to keep a simple phrase in mind. Mischief was intended. In murder, it ended. Thank you.
Ms. May, thank you very much. And if the defense would like to make its opening statement, please.
Yes, Your Honor.
Ms. Graham.
Have you had a pleasant dream descend into an inescapable nightmare? One moment you're having fun, floating, free, and the next you're stuck, sinking, and scared. Trapped in a world where nothing you do matters and the people who are supposed to care don't. On March 6th of 2020, Avery Becker's day could have been mistaken for a dream until she learned that she was living in a nightmare from which she has yet to wake. A nightmare where nothing she does matters because no one cares. She tells the police that she'll never commit a murder. They don't care. She provides an alibi and an alibi witness, and they don't care. She and her lawyers go so far, they even provide a much more plausible suspect, and the police don't care. They don't even investigate. Ladies and gentlemen, today we are asking you to care. May it please the court, Your Honor, opposing counsel, and members of the jury. My name is Kira Graham, and along with my co-counsel Liam Anderson and Caroline Dieter, we represent Miss Avery Becker. Today, the prosecution must prove each one of the elements of first-degree murder. That Avery Becker, while in the state of Colorado, alone or with someone else, committed or attempted to commit second-degree burglary, and during that crime, caused the death of Mackenzie Brackman. The prosecution must prove each one of these things individually beyond a reasonable doubt. But the defense does not have to prove anything. No, the burden of proof solely lies upon the prosecution. And after today's trial, you will see that the prosecution failed to prove that Miss Becker killed Mackenzie Brackman, that she committed or attempted to commit second-degree burglary, and they failed to prove that she was even there. You are going to hear from 6 witnesses. From the defense, you'll hear from Professor Blake Van Owen, who will tell you all about how the police chose a narrative and they stuck to it, cherry-picking through the evidence and choosing what fit it and ignoring what did not. You'll hear from the defendant, Miss Avery Becker, and her alibi witness, Taylor Perkins. You'll hear how they woke up, discovered Miss Becker's phone was missing, and retraced the steps of the night before trying to look for it. They combed to the mall, and then they combed to the fry shack, called and texted the phone, but to no avail. Why? Well, you will know why when the prosecution's witness, Miss Fuentes, testifies that she was one of the last people to have the phone before it went missing, and how conveniently she got messages from that exact missing phone incriminating Miss Becker of this crime. You will hear from Detective Markowitz how they failed to even prove those messages were real. They failed to even bother to make sure. You are going to hear from Investigator Kuzak how, when it comes to the evidence they did make sure were credible, they lost and corrupted, leaving today's case incomplete. Today, you heard the prosecution say that this case was mischief intended and with murder ended. Mischief that they will fail to prove. Mischief, our own expert will tell you that the prosecution's own evidence doesn't point to. And murder that the prosecution refused to investigate. You will hear from several witnesses about leads that the police failed to follow up on. Like the third suspect Miss Becker supplied, a Blair Rollins, who was known for hating Mackenzie Brackman for putting her father into prison, and who conveniently was best friends with Miss Fuentes, who was also known for feeling threatened by Miss Becker and who wanted her off the mock trial team. Why did they not follow up on this? Well, you will know why. Because they don't care. Because it didn't fit the prosecution's narrative. The prosecution did not want the truth. They wanted an easy blame. So they painted the defendant as a murderer and said good enough. But if at any time today, you decide that they did not frame Miss Becker well enough, that their paint job has flaws, that there is reasonable doubt in any of the elements we listed earlier today, Your verdict must be for Miss Avery Becker. Wake her up from this nightmare. Thank you.
Ms. Graham, thank you very much. And if the prosecution then would like to call its first witness.
Yes, Your Honor, the prosecution calls Ms. Kyle Cusack to the stand at this time.
Ms. Cusack, you've previously been sworn. I'll just ask you to keep that oath in mind. Thank you.
Yes,
Counsel,
Your Honor.
if you'd like to go ahead.
Thank you. Good morning. Could you please state your name and spell your last for the record?
Kyle Cusack, K-U-Z-A-K.
Ms. Cusack, what do you do for a living?
I am a Colorado Bureau of Investigation Certified Crime Reconstructor, or CSR.
How long have you been doing this?
19 years.
What does this job entail?
I investigate all sorts of complex crimes, including home invasions, burglaries, other property crimes, fatal accidents, domestic violence, and armed robberies.
Who do you work for, Ms. Cusack?
I work for the city of Denver, and I have for the past 3 years.
Your Honor, I now move to enter this witness as an expert in crime scene reconstruction pursuant to Rule 702.
All right. Does the defense have any objection, or would they like to voir dire further?
A quick here, Your Honor.
Sure, Ms. Graham, go ahead.
Now, Ms. Cusack, you never mentioned any education or degrees linking to crime scene reconstruction, correct?
No, because I'm board certified. I've been doing this for 19 years.
Yes, you also never specify any training you took for becoming a crime scene reconstructionist?
My training is working in this field every day.
And you said that you're certified, correct?
Yes.
But you provided no proof that you are certified here today, correct?
I work every day with the city of Denver, and I am certified by the city of Denver, so no, I did not feel like that was relevant.
Your Honor, at this time, the defense objects to entering Ms. Kyle Cusack as an expert in the field of crime scene reconstruction, as they have failed to provide any foundation of where she has gotten this experience, and they did not provide any knowledge or any of the other elements that you can use to enter Ms. Cusack under.
Ms. Graham, thank you very much. Ms. May, anything briefly in response?
Your Honor, I believe there are a series of things that only one of them has to be relevant for the witness to be entered as an expert. And Ms. Cusack has specified that, may I pull up my rules for?
Sure.
Your Honor, a witness may be qualified as to expert by knowledge, skill, experience, training, and or education. And I do believe that, as Ms. Cusack previously testified, to being in this field for 19 years, that does go to her experience. And in doing this for 19 years, she would have knowledge, she would have skill, and the city of Denver would not have been able to employ her if she didn't have education or training in this field.
All right, counsel, and again, when you say the field, in which area are you offering this witness as an expert witness?
Crime scene reconstruction, Your Honor.
All right, I note the defense objection, but I think a sufficient foundation has been laid with respect to this witness's education, training, and experience, and she'll be admitted as an expert qualified to offer opinions in the field of crime scene reconstruction. Issues raised by the defense can be considered by the jury in assessing the weight of the testimony, but it doesn't affect the witness's admissibility. So with that, counsel, if you'd like to continue with direct. Thank you.
Ms. Cusack, what is your involvement with the case here today?
I was called to visit the scene at 444 South Flower Street.
Whose house is this?
Mackenzie Brackman's.
Were you able to identify the victim at the scene as Mr. Mackenzie Brackman?
Yes.
Other than visiting the crime scene, did you do any other work for this case?
Yes, I also reviewed all the police reports, the evidence, the 4 Ring security camera videos, and the autopsy.
With your experienced background in this field, how do you go about conducting your investigations?
I first assume that every case is going to trial, so I conduct a thorough investigation accordingly. And then second, starting from day one, I memorialize, document, and organize all my evidence with a mindset of future reconstruction.
What is the benefit of conducting your work this way?
This ensures that I have an accurate and efficient flow of my CSR work, which I approach in a 5-step process.
What are those 5 steps?
Recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction.
Did you go through each of those 5 steps in this case today?
Yes, I did.
After gathering all of your evidence from the case, what conclusion did the evidence ultimately lead you to?
Well, the ring security videos showed a perpetrator matching the general height and build of the defendant, approaching the victim's residence and breaking in.
Your Honor, permission for the witness to view what has been previously marked as Exhibit 12.
Any objection from the defense?
No, Your Honor.
Go right ahead.
May I ask my co-counsel to share the exhibit, please? Oh, thank you.
Thank you.
Ms. Cusack, were you able to view Exhibit 12 or do you need it to be played one more time?
I'm able to view it, thank you.
Perfect. Ms. Cusack, what is Exhibit 12?
This is a video of the intruder unlawfully entering Mackenzie Brackman's home.
How do you know this?
This is the video that I reviewed in my investigations.
Is it a fair and accurate representation?
Yes.
Your Honor, I now move to enter Exhibit 12 into evidence.
Any objection for the defense?
No, Your Honor.
That'll be received. Thank you.
Co-counsel, if you could now play this video in order for the jury to watch it. Thank you. Ms. Cusack, what conclusion did this video lead you to about the perpetrator?
This video is critical because it shows the general height and build of the perpetrator, which matches the exact general height and build of the defendant, Avery Becker. It also shows that the perpetrator is wearing gloves, which is why no DNA evidence was recovered from the scene other than Mackenzie Brackman's.
Thank you, Ms. Bennett-Spurlock. You can stop screen sharing now. Ms. Cusack, you stated that along with analyzing the videos, you also analyzed a series of photographs. What did these photographs show you?
They showed scuff marks on the kitchen floor, an open knife drawer with several small knives in it, a knife block with an open slot for a large chef's knife, just like the one that we retrieved from the body, and a broken plate.
Did the photographs provide any other insight into your investigation?
Yes, the floor scuffing indicated that there was close contact between at least 2 individuals.
Ms. Cusack, did you review the autopsy report in this case?
Yes, I did.
What did it tell you?
It established that the victim was stabbed only 1 time in the upper back or shoulder area.
You mentioned that making timelines are a very important part of your reconstruction process. Did you make a timeline in this case that allowed you to come to the conclusions you came to?
I did, yes.
Can you review this timeline for us?
Yes. First, the victim must have been notified of the intruder's presence near the home due to the ring security system. He then likely looked for a defense weapon in the knife drawer, but then approached the knife block to reach for a larger knife to introduce into the encounter.
Based on the timeline, what did you conclude happened when the victim confronted the intruder?
The 2 individuals struggled over the knife in the kitchen, causing the plate to crash to the floor, and in the ensuing struggle, the intruder obtained the knife and disarmed this victim.
And based on the evidence, what were you able to conclude happened once the intruder grabbed the knife from the victim?
Well, based on the location and position of the stab wound in the body, it would be consistent with the intruder reaching over and stabbing Mackenzie Brackman in the upper back shoulder area from a bear hug position in very close proximity.
Ms. Cusack, were you aware that there were other expert witnesses who were working the case?
Yes, I'm aware that Blake Van Owen's working this case for the defense.
Did you review Ms. Van Owen's theories in this case?
I did.
Do you agree with her theories?
No.
Why?
Well, Blake Van Owen regrets to include critical evidence in this case, such as the broken plate, the floor scuffing, the open knife drawer, and the empty knife slot. And on top of that, Blake Van Owen suggests that Brackman was not even surprised, was surprised, which is ridiculous.
Why is that ridiculous?
Well, Brackman has no reason to be surprised as he owns ring security systems, which sole purpose is to notify homeowners of movement near the house. And on top of that, we just watched a video of the intruder entering the residence, and after that, the intruder walked through the kitchen. There's just so much evidence that points to the intruder making movement, and Brackman would have surely been notified.
Ms. Cusack, was your investigation in this case thorough?
Yes.
Did you have sufficient evidence to come to a conclusion?
Yes.
In your expert opinion, through your many years in the field of crime scene reconstruction, what is your conclusion of this case?
In the end, this was clearly a planned burglary gone bad. The intruder had knowledge of the victim's residence and likely chose a time of day that would have placed the victim outside of the home. However, the victim was indeed present and alerted to the intruder's presence before the intruder entered the residence. Unfortunately, however, in the ensuing struggle, the intruder obtained the knife which the victim brought into the encounter in the first place and murdered Mr. Brackman.
Thank you. No further questions at this time, Your Honor.
Ms. May, thank you. Ms. Graham, if you would like to cross-examine, please.
Yes, thank you, Your Honor. Ms. Cusack, good afternoon, Ms. Cusack. My name is Kira Graham, and I will be asking you some questions. Before we begin, please tell us who you're certified by.
The Colorado Board.
Thank you. And Ms. Cusack, you are a certified crime scene reconstructionist, correct?
Yes, I am.
And would you agree that the very essence of crime scene reconstruction is sequencing events?
Yes.
But isn't it true that you were not able to recreate all event segments?
It's impossible to recreate all event segments, but considering all the evidence I had, I was able to make an 100% conclusion in this case.
You were also not able to place all the evidence in your crime scene reconstruction. Isn't that true?
Like I said, this is impossible. You can never place all of the evidence. You can just use your expertise. I mean, I've been doing this every day for 19 years, so I'm fully confident in my evaluation.
And since you were not able to recreate all event segments or place all the evidence, your crime scene reconstruction is still not 100% complete. Isn't that true?
You know, it's 100% complete to the best of its ability. I was able to paint a picture for the jury of what happened, and I was able to place all the evidence to the best of my ability, so.
And isn't it true that your conclusions are based off of this crime scene reconstruction that has missing evidence and that has missing event segments, correct?
Although unfortunately there is some missing evidence, I was able to review all of the evidence prior to it being missing, and I was able to develop a full conclusion, and I'm fully confident in it.
I'm sorry, is that a yes or a no, Ms. Cusack?
Can you repeat the question?
Isn't it true that your conclusions are based off of this crime scene reconstruction that has missing event segments and missing evidence?
Yes.
Thank you. Ms. Cusack, was there any DNA evidence found at the crime scene?
No, we just watched a video of the perpetrator wearing gloves, which is why the only DNA evidence recovered was from Mackenzie Brackman.
And there were no fingerprints belonging to the defendant either, were there?
No, that would be impossible. They were wearing gloves.
And wouldn't you agree that DNA evidence is important to a crime scene investigation?
I mean, of course, I would have loved DNA evidence. However, like I said, we just watched the video. They were wearing gloves. It would be impossible for there to be fingerprints at the scene or any other DNA evidence.
Is that a yes? DNA evidence is important to a crime scene investigation?
Yes, of course.
So wouldn't it be important to document and take photos of that DNA evidence?
Yes.
However, some photos of DNA evidence was lost, wasn't it?
Some photos of the evidence were lost. However, I was able to review them prior to this.
So the police lost an important piece of evidence and an important piece of the investigation when they lost the photos, correct?
Yes, it was very unfortunate. However, like I said, I was able to review all of this evidence prior to this, and I was able to incorporate what I saw and all the things that I saw at the crime scene, as well as all the evidence that I was able to review before it was lost to incorporate into my investigation.
And isn't it true that there is no physical evidence found at the crime scene linking my defendant to this crime?
No, like we just watched, she was wearing gloves, so that would be impossible.
Thank you. No further questions, Your Honor.
Graham, thank you. Ms. May, do you have some redirect for this witness?
Yes, Your Honor. Ms. Cusack, how long have you been working in the field of crime scene reconstruction?
19 years.
Are you certified?
Yes.
Ms. Cusack, did you review Exhibit 12 in this case?
Yes, I did.
What did Exhibit 12 show you?
Exhibit 12 was very crucial.
Out of the scope of my cross, I never mentioned Exhibit 12 anywhere in my cross examination.
Permission to respond?
Sure, Ms. May, go ahead.
In her cross, she asked about the DNA evidence, which was Ms. Cusack did answer regarding Exhibit 12, which was the video which showed the perpetrator entering in with the gloves. So by asking about the DNA evidence, that was referencing Exhibit 12.
Objections overruled. Thank you, Ms. Graham.
Ms. Cusack, would you like me to repeat the question?
Yes, please.
Did you review Exhibit 12 in this case?
I did.
What did it show?
It showed the build of the perpetrator, which matched the exact general height and build of the defendant, Avery Becker.
Did you have sufficient evidence to come to a conclusion in this case?
Absolutely.
Thank you. No further questions, Your Honor.
Counsel, thank you. Anything else for the defense as to this witness? Ms. Graham.
Yes, Your Honor, a recross.
Go right ahead.
Ms. Cusack, you mentioned that the defendant has a matching height and build to the person in the video, correct?
Yes.
But isn't it true that other people could also have that same height and build?
Considering that the defendant is our prime suspect and Exhibit 12 matches her exact general height and build, this was very critical and linked all the ties that we needed.
That is not what I asked. I asked if it was possible that there were other people with that general height and build.
Sure, I'm sure somebody else in the world has that same height and build.
And isn't it true that Blair Rollins has that same height and build?
This is not in my statement. Would you like me to answer?
It is in your statement, though, that you reviewed Professor Blake Van Owen's review on this case, correct?
I reviewed Blake Van Owen's theories.
Excuse me?
This was not brought up in my redirect about Blake Van Owen's theories.
Okay, Ms. Graham, your response?
Your Honor, they brought up the general height and build, and Ms. Cusack knows of Blair Rollins' height and build from Professor Blake Van Owen's statement. So her saying that it is not in her statement is incorrect, and I was simply bringing it up to let her know that, in fact, it is in her statement.
Objections overruled. Thank you.
It is in your statement that you reviewed Professor Blake Van Owen's review on this case, correct?
I reviewed Blake Van Owen's theories, but I did not write Blake Van Owen's affidavit.
Yes, but you are aware in his review that he says that Blair Rollins matches Blair Rollins matches Avery Becker's height and build, correct?
I'm aware that Blake Van Owen wrote that in her affidavit. However, I am not aware as to Blair Rollins' actual general height and build.
No further questions, Your Honor.
Thank you, counsel. Ms. May, anything else?
No, Your Honor.
All right, this witness can step down. Ms. Cusack, thank you very much. And if the prosecution would like to call its next witness, please. And as you're doing that, I'm going to step out of chambers here and step into the courtroom, which is something I should have done early on, except I don't have that here. Never mind. Yes, Ms. Senishin, go ahead.
Your Honor, the prosecution calls Detective Markowitz.
All right. And if Detective Markowitz, good morning. Make yourself comfortable. You've previously been sworn, and if the people would like to conduct their examination.
Good morning, Detective Markowitz. What do you currently do for a living?
I'm a homicide detective with the Denver Police Department.
And how long would you say you have been working in law enforcement?
I have been a cop for 13 years now, but a homicide detective for 7.
And do you have any specialized training as a detective?
Yeah, actually, I received specialized training with cell phones. After completing a certification course, I received my cell phone technology and forensic data recovery certification from the American Academy for Law Enforcement.
And do you use what you learned in this training a lot in your work as a detective?
Frequently. I mean, I've downloaded the contents of literally hundreds of cell phones in cases like this one, and I've interpreted cell tower data very similar to the crucial data from this case in, I think, over 50 cases now.
Your Honor, at this time, based on the witness's extensive experience, training, and certification from the American Academy of Law Enforcement, we move to enter Detective Markowitz as an expert in homicide investigation, as well as cell phone data recovery and analysis pursuant to Rule 702.
And would the defense like to voir dire?
Yes, Your Honor, a brief voir dire.
Go ahead, Mr. Anderson.
Detective, you mentioned having training in cell phone analysis, correct?
Yes, my certification from the American Academy for Law Enforcement.
But the course that you took, the training course that you took was only 3 days, correct?
Yeah, that's how long the certification takes. But like I said, I've downloaded the contents of hundreds of phones.
You also claim to be an expert in homicide investigations.
I don't
Correct?
claim to be, that's my job. I am an expert.
Detective Markowitz, you aren't entered as an expert in homicide investigations yet, correct?
Sure, but I mean, that's my job.
However, you never mentioned receiving any specialized training in that field, do you?
I mean, I could tell you about my education, but your specialized training is working every day in the field.
You also never mentioned receiving any sort of formal degree or education in that field, do you?
I haven't been to college in a long time, so no, I didn't mention that.
Is it your statement here today that you went to college?
No, it's not my statement that I went to college. My statement is that I did not mention my education in my statement.
And you also never specified how many homicide cases you've worked on, correct?
No, but I did mention that over hundreds of them have involved phones.
Thank you, Detective. Your Honor, at this time, the defense moves against the entrance of Detective Markowitz in the fields of cell phone analysis due to a lack of training, as well as the field of homicide investigation due to a lack of education, training, and experience.
For the people, anything briefly in response? Ms. Senishin?
Yes, Your Honor. As my co-counsel stated earlier, under Rule 702, a witness must demonstrate only one of 5 things in order to be entered as an expert. They must demonstrate knowledge, skill, experience, training, or education. And my witness has demonstrated extensive experience and training through her training course in homicide investigation, as well as cell phone data recovery and analysis. She's more than qualified to be entered as an expert in these areas.
Okay, and I will receive the witness as an expert qualified to offer opinions in the fields of homicide investigation, cellular data recovery and analysis. Any concerns expressed by the people, again, or by the defense rather, go to the weight of the jury may wish to give the weight of this witness's testimony, not its admissibility. Thank you. Go ahead, counsel, with your direct.
Thank you, Your Honor. Detective, how are you involved with this case?
On March 6th, I was assigned to investigate the death of Mackenzie Brockman.
And did you visit the crime scene?
Yeah, I was able to visit the crime scene immediately after the crime occurred.
What did you observe upon arriving at the crime scene?
So when I first arrived, I noticed Mackenzie Brackman, who was face down in a pool of his own blood just inside the doorframe of his house. And a large knife was visible next to Brackman, which clearly had been the murder weapon, and it was lying right next to his body inside the home.
So what did you do after making these observations?
So after I made these observations, I actually did not enter the home through the front door. I walked around the home, noticing 3 Ring security cameras. Then I entered the home through the back door, and I noticed that the house was in a bit of a state of disarray. There was a tipped over chair and a broken plate on the floor.
Okay, and what else did you observe within the residence?
Well, when I walked into the kitchen, I noticed that there was a knife block with a slot missing, which clearly contained a large chef knife, just like the one that was next to Mr. Brackman, and also a partially open knife drawer.
So what conclusions were you able to draw based on these observations?
Based on sort of the knife evidence and the evidence of the tipped over chair and the broken plate, it was pretty clear that a struggle had occurred from within the home. I concluded that Brackman confronted the intruder with the large knife from the knife block, and in a struggle, the intruder got the knife from Brackman and ended up fatally stabbing him.
And what did you do next in your investigation?
So I turned to the evidence, as I always do, to determine who murdered Mackenzie Brackman. So I actually previously knew that Mackenzie Brackman was a defense lawyer, but I downloaded the contents and then looked through his phone and noticed that Mackenzie Brackman was really into something called mock trial. He was a coach at Colorado.
I'm sorry, was that an objection?
Yes.
Would you state, what is the objection, counsel?
As to speculation.
Response, counsel?
Your Honor, could I ask the opposing counsel to confirm which statement of Detective Markowitz he is objecting to?
Mr. Anderson?
I was objecting to her statements surrounding what Mr. Brackman liked and what Mr. Brackman was into. She would not have personal knowledge of Mr. Brackman's inner feelings.
Ms. Senishin?
Yes, Your Honor. This witness concluded that Mr. Brackman spent a lot of time doing mock trial and may have enjoyed the activity based on her observation during her investigation that this Brackman had a lot of content related to the activity. So it is rationally, it is based within her perception, and she is an expert.
Overruled. Thank you.
Detective, after learning that Mr. Brackman spent a lot of time coaching mock trial, what did you do?
So as I said, I looked through his phone and Brackman had a whole lot about mock trial. So I actually got the contact information for some kids on the team, and I reached out to a student named Alex Cifuentes.
Okay, and what did you learn from Ms. Alex Cifuentes?
Lucky for me, that first phone call was my first big break in this case. Alex told me that another student on the team—
Objection, Your Honor, hearsay.
Counsel, Ms. Senishin?
Yes, Your Honor. This statement is not hearsay because it is offered to demonstrate the effect on the listener, who in this case was Detective Markowitz. As the witness said, it was a turning point in her investigation.
Mr. Anderson, anything else?
Your Honor, this statement is being offered for the truth of the matter asserted, as it's being used to build foundation for further questioning as to the interview with Mr. Cifuentes.
I understand the objection. I'll overrule the objection. Thank you. Do you need to hear that question again, Detective?
Yes,
please.
Of course.
I'll note the objection.
Detective, what did you learn from Ms. Cifuentes?
As I said, I learned something pretty big. Alex told me that another student on the team, Avery Becker, had texted her about a plan to trash Mr. Brackman's home out of revenge.
And what did you do after learning that she had received texts actually about a plan to trash the house?
I mean, based on our phone call, I had Alex Cifuentes and her parents come in for an interview right away. She told me more about Avery and Mr. Brackman's relationship, and I asked to see the text, but she had forgotten her phone, so I later asked for screenshots of this conversation.
Okay, and what did you do after the interview with Miss Cifuentes?
So I first attempted to interview Avery Becker, but Becker lawyered up, and so I couldn't. And so then I obtained a warrant to search Becker's phone, which once again, Avery's attorney told me that Becker had lost the phone. So then I finally got a warrant to get the cell tower data relating to Mrs. Becker's phone on March 6th.
And could you tell us about how cell tower data helps investigation?
Absolutely. So CDR records are going to be super helpful in cases like this one, especially because they tell us a general idea of a phone's location.
And how do they do that, Detective?
So when you make or receive a call or text, your phone is going to communicate with a cell tower, specifically an antenna, right? And so by getting the data that tells us the location of these cell towers, we actually can know within what range the phone was throughout that day. And so it helps us paint a general picture of where the defendant was on that day.
Detective, do you have an accessible copy of Exhibit 16?
Yes.
Could I ask my co-counsel to also screen share Exhibit 16?
Please.
Detective, what is this exhibit?
Yes, so this is a diagram that I prepared myself, and it shows the route that I believe Becker took to Brackman's home.
How do you know this?
Because I prepared it myself.
And is it a fair and accurate representation of the diagram you prepared?
The one on the screen absolutely is, yes.
Your Honor, at this time, we move to enter Exhibit 16 into evidence.
Mr. Anderson, any objection?
Yes, Your Honor. Objection as to hearsay.
Ms. Seneschal, your response?
Your Honor, I guess I'd like to ask opposing counsel to specify how they see this as a statement of some sort.
Mr. Anderson?
Your Honor, Ms. Markowitz drew these arcs as well as the line on this map, and even previously said that these were basically a translation of her opinion as to the path the defendant took, and therefore she's making a statement as to her opinion on where the defendant's phone was.
I understand the objection. I'll overrule the objection and receive the exhibit. Thank you.
Your Honor, permission for this witness to annotate the exhibit?
Mr. Anderson, subject to your earlier objection, do you have any objection to Detective Markowitz marking the exhibit?
No objection, Your Honor.
All right, go right ahead as necessary.
Thank you, Your Honor. Detective, could you tell us a little bit about this exhibit?
Of course. So let me mark. These red arcs on this diagram, we've got 3 of them. 1, 2, 3. They're actually going to represent the specific antennas that Becker's phone communicated throughout the day. And next to them over here, we're going to see the times that a call or text was received.
So did Becker's phone receive any other communications later on the day of the murder?
Becker actually only received the communications, these 3 series of communications. So the first one at 12:47, down here, these communications was at 12:55, and then 3 communications down here, which were at 1:05, 1:06, and 1:17. But to answer your question, no, after this time, Miss Becker's phone was turned off, probably because it was disposed of after the murder.
Okay, and what conclusions were you able to draw based on this data?
Well, it's very clear that Miss Becker's phone was moving. And so here's Miss Becker's house and moving towards Mr. Brackman's house. Brackman's is down here. So this dotted line is the path that I believe Avery Becker took from her home to Mr. Brackman's home on that day.
Thank you, Detective. This exhibit can be removed from screen share. Thank you. Detective, in your expert opinion, how was Brackman murdered?
Well, the evidence has clearly shown that Avery Becker went to Mackenzie Brackman's house on Friday, March 6th of 2020, with the intent to trash Mr. Brackman's home. Avery did not intend murder, which is why she did not bring a knife to the scene. However, when Avery approached the residence that day, Mr. Brackman was alerted to her presence and grabbed a large knife from the knife block. Then a struggle ensued, and Avery actually got the knife from Mr. Brackman and ended up fatally stabbing him in the back.
Thank you, Your Honor. Thank you, Detective. No further questions.
Mr. Anderson, cross-examination, please.
Yes, Your Honor. Detective Markowitz, you were one of the first detectives at the scene, correct?
Yes.
And you began your investigation as soon as you arrived, didn't you?
Yes, I did. I saw Mr. Brackman laying in a pool of his own blood the first thing I got there.
And as part of your investigation at the crime scene, you took some photos, didn't you?
Yes, I did.
And specifically, you took photos of a purported blood spatter and blood drops, correct?
Yes, I did. Mm-hmm.
But those photos aren't here today, are they?
Some of the photos of blood splatter were corrupted in this case, and seeing that I'm not an expert in blood splatter, it's not really relevant to my case anyway. The struggle was apparent from other evidence.
Detective Markowitz, these photos were in your care when they were corrupted, correct?
They were in the care of my police department.
Yes, and they were in the care of specifically your investigation team, correct?
Yes, my team.
Detective Markowitz, you also interviewed Ms. Cifuentes as part of your investigation, correct?
Yes, I did. Ms. Cifuentes told me that Avery Becker had a plan to trash Brackman's home.
And as part of that interview, you asked her to see her phone, correct?
Yes, I did, to see the text conversation that I just discussed.
But Cifuentes supposedly forgot her phone, correct?
Not supposedly. Cifuentes did forget her phone.
And you asked Cifuentes to send you text messages, correct?
I did.
And when Cifuentes took pictures of these text messages, Cifuentes was not supervised by a police officer, correct?
I couldn't tell you. She wasn't supervised by me.
She wasn't supervised by a police officer, correct?
I don't know if she was supervised.
What's the objection, counsel?
Lack of personal knowledge.
Mr. Anderson?
Your Honor, Detective Markowitz was the lead investigator on this trial, and so she would have personal knowledge, especially as to her own witnesses and how interviews were conducted with that witness.
Okay, normally I might require that the witness lay some additional foundation, but I think in the interest of time, I'm going to overrule the objection.
Okay. And Ms. Cifuentes was just a high schooler at the time she took these photos, correct?
Yeah.
And Ms. Cifuentes is not a police officer, correct?
No, Ms. Cifuentes is not a police officer.
And you relied on these photos in forming your opinion in this investigation, correct?
Yes, I did. They led me to Avery Becker, and then the surplus of other evidence confirmed that Avery Becker committed this murder.
So you relied on photos collected by a lay witness, a high schooler to be specific, in your investigation.
Yes,
Correct.
As a police officer, most of my evidence comes
Ms.
from lay witnesses.
Ms. Markowitz, are you aware of a program called Photoshop?
Yes, I am.
You are aware that somebody can edit photos with that program, correct?
That's not in my statement. Would you like me to answer that?
Yes.
Ms. Cifuentes didn't have Photoshop on her computer. I searched it.
Detective Markowitz, that wasn't my question. My question was, you are aware that somebody can edit photos using Photoshop, yes or no?
Yeah, sure.
And you presented no proof that Ms. Cifuentes did not use this program, correct?
That's not in my statement. Would you like me to answer that?
You presented no proof at trial today that Ms. Cifuentes did not use that program, yes or no?
No, I did not in trial today.
Now, Ms. Markowitz, there were 3 suspects in this case, correct?
That's not in my affidavit.
You conferred with Investigator Kuzak. on this case, correct?
I did.
And did Investigator Kuzak make you aware of the additional suspects?
That's not in my affidavit.
Investigator Kuzak make you aware of additional suspects, yes or no?
Objection, Your Honor.
Excuse me, counsel, the objection?
This calls for hearsay.
Overruled.
I'll ask again. Did Investigator Kuzak make you aware of additional suspects?
That is not in my statement.
Yes, I would still like you to answer. Did Investigator Kuzak make you aware of additional suspects?
No, Kuzak did not.
Now, you also testified that you investigated the call detail records of Mrs. Becker, correct?
Yes, and they clearly show Becker traveling to Brackman's home.
But call detail location records aren't 100% accurate, are they?
No, they're not.
And in fact, a phone can connect to a further away tower for any number of reasons, correct?
Not for any number of reasons. There's a very specific algorithm.
Yes, location could be one reason, correct?
No. The only possible reason is if the tower is too busy.
Sure, if the tower is too busy. Now, Ms. Markowitz, or Detective Markowitz, so you can't confirm that Ms. Becker's phone was within those arcs that you drew, correct?
I can confirm that Miss Becker's phone communicated with those arcs.
Yes, you can't confirm that they were specifically within those red arcs that we saw earlier, can you?
No, I cannot, but I also can't confirm that aliens didn't have the phone that day.
Detective Markowitz, did you pull the call detail location records for Mr. Perkins in this case?
No, I didn't.
So you chose not to collect, and Mr. Perkins is a alibi witness, correct?
Yes, and I had already disproved Avery's alibi, so I didn't need Mrs. Perkins's records.
So you didn't feel like that evidence was at all relevant?
I had already proved that Avery was lying about her alibi.
And you didn't feel the need to double check your work in any way?
No.
Thank you, Your Honor. No further questions.
Mr. Anderson, redirect for the people, Ms. Seneschal.
Yes, Your Honor, briefly.
Sure.
Detective, you just said that Alex Cifuentes sent you screenshots of her text communications with Avery Becker, the defendant. Did this affect your investigation or conclusion in any way?
No. The screenshots led me to Avery Becker, but ultimately it was the struggle, the ring video, the knife block that led me to this conclusion of Avery Becker.
Thank you, Your Honor. No further questions.
Mr. Anderson, anything else?
Yes, a brief recross.
Okay.
You previously testified that the screenshots that Ms. Cifuentes took became a part of the investigation on which you based your opinion, correct?
Yes.
No further questions, Your Honor.
Thank you. Anything else, Ms. Seneschal?
No, Your Honor. Thank you.
All right, Detective Markowitz, you can be excused. Thank you very much. And if the people then would call their next witness.
Yes, Your Honor. The prosecution calls Miss Alex Cifuentes to the stand.
Cifuentes, thank you. And you've previously been sworn. And Ms. Humber, if you'd like to go ahead then.
Your Honor, before we begin, could the prosecution have a brief time check?
Sure. And what I'm reading is 7:45 remains for prosecution direct. Are we on the same page there? Great. Okay.
May I proceed?
Yes, ma'am. Go ahead.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Alex Cifuentes. That's Sifuentes.
Ms. Cifuentes, where do you go to school?
Currently a senior at Colorado High School. Go Eagles.
What kind of activities are you involved in?
Well, I recently joined the Ping Pong Amateurs Club, but my favorite and by far most time-consuming activity is certainly mock trial.
Could you tell the jury about your involvement in mock trial?
Certainly. I've done it all 4 years of high school. I love it. I'm usually an attorney. I always awaited the day that our coach would assign us the roles, and I'd go right home and dig into the case.
Do you see anyone here today who did mock trial with you?
Yes, I believe I saw Taylor Perkins and Avery Becker.
Were you friends with the defendant?
Yes, I was good friends with her. We did mock trial all 4 years together. She was the one who even introduced me to mock trial
Objection,
in the
Your
first
Honor.
place.
Oh, actually, I apologize. I withdraw my objection.
Okay.
Permission to proceed?
Yes, ma'am.
Should I continue?
Yes, you may
I'll
go
re-
ahead. Amber.
I
I'll
was
re-ask-
really good friend. Oh, go ahead.
I'll re-ask the question. Were you friends with the defendant?
Yes, I was good friends with the defendant. We did mock trial all 4 years together. She introduced me to mock trial my freshman year. You know, you're bound to get close with someone that you spend literally hours a week with.
What was the defendant like on the team?
Avery's saving grace was that she was really good at mock trial. She was really good on the stand. You know, she could sway a jury. She's a really good liar, a good actress. You know, she just has that way about her. The problem was like she just didn't put in a lot of effort on the team. She didn't show up very prepared a lot. She would show up late to practice, and I didn't like how she treated our coach one bit.
How did she treat Mr. Brackman?
Basically, Avery would just refute pretty much everything Mr. Brackman said. He was a criminal defense attorney. Like he did that for a living, and she completely ignored his advice, ignored his comments. And she showed up to regionals really, really unprepared, like flying off the script. And Brackman, or no, not regional. She showed up to practice one day, really, really unprepared, just flying off the script. Didn't know what she was talking about, and Brackman demoted her to B team for that.
Did she react to the demotion?
She threw a fit. Precious Avery could not be on a B team. So basically, at that
Objection,
point,
Your Honor. Speculation.
Ms. Humber, your response?
Your Honor, may I ask counsel to confirm on what grounds?
May I
Can we
respond?
restate the objection, please?
I objected to speculation. Opposing counsel was asking the witness to testify on whether or not, on how Ms. Becker reacted to that situation. And she has not provided foundation as to whether or not she was present or would have the knowledge to actually be able to testify as to how she reacted.
Any brief response, Ms. Humber?
Yes, Your Honor, I'm happy to lay further foundation if this is a foundational issue. However, this is a testimony by a lay witness. She is rationally based on her perception, and it is not based on any scientific knowledge within the scope of 702.
May I respond, Your Honor?
I'm going to overrule the objection, but thank you.
Would you like me to repeat the question?
sure.
Did she react to the demotion?
Basically, she threw a fit. And at that point, if a team had lost another person, we weren't going to be able to go to regionals. So her really good friend, Taylor Perkins, he quit the team completely, and Avery had to be let back on. But she was only on the team for a little bit after that.
How come she was off the team again?
Well, basically, at regionals, she just was completely unprepared. She went off script. She ignored all of Mr. Brackman's advice. And he afterwards talked to her about it and was like, you know, you can't just do that. You can't just fly off script for that. Like, you can't just show up at a trial and expect your client to get acquitted. You know, that'd be malpractice in the real world. And he explained this to her, and she left practice with a Sharpie, fuming.
What did she do with the Sharpie?
Well, she went out to the parking lot, climbed up on Mr. Brackman's super, super nice 911 Porsche, and wrote in big letters, "Worst Attorney Award." I know.
Did Mr. Brackman press charges?
Personally, I don't know of any charges he pressed. All I do know is that she did get kicked off from our trial team for good this time.
Did the defendant accept this punishment?
Absolutely not. She was texting everyone on the team, including me, asking us to help her get back on the team, like talk to Brackman about it.
Your Honor, permission for my technician to present this witness with what has been previously marked as Exhibit 14.
Yes.
My apologies, that's the wrong exhibit. It's not allowing me to share. Just give me 1 second, sorry.
If there's an issue, I can share if that helps. I know technologically it's kind of.
It should be okay, just 1 second.
Thank you for offering. I appreciate that. Thank you, Ms. Spurlock. If you could scroll through that document. Ms. Cifuentes, do you recognize this exhibit?
Yes, these are screenshots of the text messages between Avery and I after she got kicked off the team, the screenshots that I sent to Detective Markowitz.
Are these a fair and accurate representation?
Yes.
Your Honor, we move to enter Exhibit 14 into evidence.
Any objection, Ms. Dieter?
Yes, Your Honor, to hearsay.
Your response, Ms. Humber?
Your Honor, pursuant to Rules 801D1 and 801D2, the statements herein are made by the current declarant, as Ms. Cifuentes, as well as the party opponent, in this case, Avery Becker.
I'll overrule the objection and receive the exhibit. Thank you.
If I could have Ms. Bennett Spurlock turn this document to page 2. Thank you. Ms. Cifuentes, could you give the jury a summary of the defendant's request?
Yes. So basically, Avery asked to get back on the team, or asked me to help her get back on the team. Can I annotate?
Your Honor, permission for this witness to annotate?
Any objection, Ms. Dieter?
No, Your Honor.
Go ahead, Ms. Cifuentes.
So basically here, she asked me if there's any way I'd be willing to talk to Coach Brackman about having her back on the team, which I did. I did go talk to Mr. Brackman.
What did she say next?
Well, basically I explained to her, like, Mr. Brackman completely shut me down. And I wanted to go to state, so I wanted to get her back on the team so we could go to state, but he completely shut me down. Like, it was just not going to happen. And she said right here, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. So then I said, what are you going to do to his house? And she said, I'm going to wait until he's at work and break in and trash it, referring to the house.
I see. Did you ever ask what she meant by this?
I told her that I didn't think it was a good idea, but I didn't ask her what she meant, and I guess I should have.
Thank you, Ms. Cifuentes. Ms. Bennett Spurlock, you can stop sharing the screen now. Ms. Cifuentes, did you see the defendant on March 6th?
No, Avery was not at school that day. We have some classes together and she wasn't at school. And the next thing I knew, Mr. Brackman was murdered.
Thank you, Ms. Cifuentes. Your Honor, no further questions at this time.
All right, counsel. Thank you. Ms. Dieter, if you'd like to cross-examine. Excuse me for just 1 moment.
Should I wait before proceeding?
No, go right ahead. Stand to.
Good morning, Ms. Oh, I apologize.
No, go ahead. My fault.
Good morning, Ms. Cifuentes. My name is Caroline Dieter, and I'm going to be asking you some questions today. If you could keep your answers to a short yes or no, that would be ideal. To start off, I would like to clarify a few things. It was your testimony here today that you did mock trial with Ms. Becker for 4 years, wasn't it?
I am a senior now and she graduated, so I did it with her for all the years that she was at school.
But it was your testimony here today that you did mock trial with Ms. Becker for 4 years, was it not?
I guess I misspoke. I did it for all the years that she was at school doing it.
I see. And you also testified that Ms. Becker was very talented, didn't you?
She was. She was a very good witness, a good actress.
And you made a statement before coming here today?
An affidavit statement?
Yes.
Yes, I did.
You signed that statement?
I did, yes.
You signed that it was true?
Yes, yeah.
Accurate?
Mm-hmm.
And up to date?
Yes.
And that you would update it should you have any new information come to light?
Yes.
And in that statement, you say that Ms. Becker has no real talent at all, correct?
You know, Miss Becker was not very good at mock trial. She wasn't good
Is
in
that
the
a yes
work.
or a no, Ms. Cifuentes?
May I explain?
Yes, you may.
So Avery did not put in the work. She didn't put in the time. And for that, I don't think she was very talented at mock trial. She was talented at lying, though.
I did not ask if she was talented at lying. I simply asked if you said that she was not talented at all. Is that a yes or a no?
Could you repeat the question? Are you asking if I said that she was not talented at all?
Yes.
Sure.
I see. Moving on, I would like to discuss deeper about your relationship with the defendant. You thought that she always played victim, didn't you?
Yes.
And she got on your nerves quite a bit, correct?
Yeah, she did.
So much so that you would ask Mr. Brackman over and over again, wondering why he put up with her.
I
Isn't that
asked
right?
him once how she was even still on the team with the lack of work she put in.
Is it your testimony here today that you only asked him once?
I think I remember only once, but could have been more.
I see. And Miss Cifuentes, you thought that Miss Becker refused to work hard, correct?
Yes, she did.
May I pause time for a moment? I would like to just get a time check because I did forget to. Thank you, Mr. Howe. I am ready to proceed. My apologies.
Not at all.
Miss Cifuentes, you thought Miss Becker refused to work hard, correct?
Yes.
And you, on the other hand, you took meticulous care and time making your examinations, right?
Of course, that's what mock trial is about.
And Miss Becker, on the other hand, she would make things up on the fly, wouldn't she?
Yes, she would.
And even with that, and your differences in methods, you were still equally skilled, were you not?
I thought we were pretty equally skilled. She didn't put in the work, though, but you could say so.
Right. Moving on. I would like to talk about the night before the murder. You were at the Fry Shack, weren't you?
Yes, I was at the Fry Shack.
And Miss Perkins and Mr. Perkins and Miss Becker were there as well, correct?
Yes, I did see them there.
You actually spoke to Miss Becker that night, didn't you?
Yeah, we had a conversation.
She even let you use her phone before she left, didn't she?
Yeah, she let me play a game on it.
And later on in this investigation, you volunteered to offer supposed screenshots of a text conversation that might have taken place between you and Miss Becker, correct?
Yeah, after she got kicked off the team.
And these text messages were the main reason that you even had to come down to the police station for an in-person interview. Isn't that correct?
The detective and I talked about the screenshots on the phone, and then she had me come in for an interview. And we also talked about,
Is that a yes?
Avery. We didn't only talk about the screenshots of the interview.
I said the main reason. So would that be a yes, Ms. Cifuentes?
Sure, yeah.
And Detective Markowitz did not make you come back to verify these texts' authenticity after you forgot your phone?
No, she said the texts were enough.
And those texts are still being shown in court here today, regardless of the fact that they have not been verified as authentic. Isn't that right?
I don't know what the detective did or didn't do to verify the authenticity. I don't know how that works, but yeah, they were my screenshots.
But I asked if they are being shown here without having been verified.
I don't know.
Objection outside of the scope.
Overruled.
I'm sorry, what was the objection? Oh, okay.
Can you
Ms.
repeat the
Cifuentes,
question?
I'm asking if you went to verify them. You said that you did not. So I am simply asking if they are being shown in court here today, regardless of that fact.
I don't know what the detective does to verify these texts. All I know is that I sent them to the detective and she accepted them.
Thank you, Your Honor. No further questions.
Ms. Dieter, thank you. Ms. Humber, redirect.
Briefly, Your Honor.
Sure.
Ms. Cifuentes, You saw the text earlier. Was this a real conversation between you and Avery?
Absolutely.
Do you have recollection of sending the messages in green on the right?
Yes.
Do you have recollection of receiving the gray messages from Avery Becker on the left?
Yes. We were in mock trial all 4 years. We texted about mock trial, usually all the time. I would know if it was Avery, and it was.
Did you fabricate or alter these messages in any way?
No, I don't know how to work Photoshop.
And Ms. Cifuentes, what did the defendant state in these messages?
She said that she was going to go to Mr. Brockman's house while he was gone working and trash his house.
Thank you, Ms. Cifuentes. Your Honor, no further questions at this time.
Ms. Dieter, if you have one or two brief questions in recross, happy to hear them.
No, Your Honor.
All right. Thank you then. May this witness be excused?
Yes, Your Honor.
Thank you, Ms. Cifuentes. You've completed your testimony. Do the people have further witnesses to offer at this time or anything else to take up?
No, Your Honor, the prosecution rests.
All right, the prosecution rests. With that, would the defense like to call its first witness, please?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
All right. And Professor Van Owen, you've previously been sworn. So, Mr. Anderson, if you'd like to go ahead.
Good morning, Professor Van Owen. Could you please introduce yourself and spell your last name for the jury?
Of course. My name is Professor Blake Van Owen. Van Owen spelled V-A-N space O-W-E-N.
Why are you here today, Professor?
I'm here today as a private investigator and the lead person in charge of investigating police practices for the defense.
And what principles do you investigate in your work as a private investigator?
I investigate police practices, cell tower analysis, forensic evidence techniques, and cell tower analysis.
Have you ever testified as an expert on any of these subjects before?
I have, yes. I've testified in U.S. state and district courts over 100 times.
And how did you acquire your expertise?
I have worked as a police officer, school resources officer, private investigator, and have received various education in my field.
Could you please describe what sort of education you've received?
Of course. I received my master's degree from the University of Ashford in criminal justice.
And when you aren't working on court cases, what do you do?
When I'm not working on court cases, I work as a professor at the University of Colorado, Denver, and I lecture on police practices and social justice.
Your Honor, at this time, the defense moves to enter Professor Blake Van Owen as an expert in the fields of police practices, forensic evidence techniques, cell tower analysis, crime scene reconstruction, and police investigation tactics.
Ms. Humber, would you like to, do you have any objection or would you like to voir dire?
Permission for a brief voir dire, Your Honor.
Sure.
Ms. Van Owen, you claim to be an expert in cell tower analysis?
Yes.
Yet, of the cases you've worked on, less than 5% have involved analyzing cell towers.
5% of the cases that have gone to court, yet I apply these practices every day in my life as a private investigator.
You have no specialized training with cell towers.
I reviewed cell towers upon obtaining my master's in criminal justice.
Criminal justice is very different from criminal investigation. Can you agree?
Well, it might be different. We do review many police practices, and I also worked on the police force. So I have reviewed this subject various times upon my education and apply these practices every day in my life.
Thank you, Ms. Van Owen. You also have no specialized training in cell phone data?
Once again, while I don't have specialized training, I use it as a private investigator every day.
No specialized training in forensic software for cell phones?
No, but once again, I use it every day in my life as a private investigator.
Neither for cell data records or cell phone technology?
Once again, no, but I use it every day as a private investigator.
Your Honor, pursuant to Rule 702, we don't object to Ms. Van Owen being entered as an expert. However, we do object to her being entered as an expert in cell tower analysis for lack of education, skill, knowledge, and training in the field of cell tower analysis.
Mr. Anderson, your response?
Your Honor, the witness has testified as to her experience in all of these fields and that she has worked on many court cases utilizing these skills, as well as her education in the field of cell phone analysis and data recovery.
All right, I understand the objection. I'm going to receive this witness as an expert in the areas endorsed over the objection of the people. The jury can consider the arguments with respect to the weight they wish to give the testimony. Go ahead. Thank you.
Professor Van Owen, before we begin, did you form any overall opinions on this case?
Yes, I believe that the prosecution's evaluation of this case was very rushed, and there are a lot of missing pieces.
In your investigation, did you get a chance to review the coroner's report?
I did, yes.
And was this report made public?
Yes, in the state of Colorado, autopsy reports are public records.
If my co-counsel could please pull up Exhibit 19 for purposes of identification. Professor Van Owen, do you recognize this?
I do, yes.
What is it?
It is the autopsy report done in this case.
And how do you know this?
I know this because I reviewed it upon my investigation.
And is this a true and accurate copy of that report?
Yes, it is.
Your Honor, at this time, the defense moves to enter Exhibit 19 into evidence as its accuracy has been shown and authenticity stipulated to.
Ms. Umber, any objection?
No, Your Honor, any issues will be addressed on cross.
Thank you. That'll be received then.
Thank you. If co-counsel could please take down the exhibit. What are your thoughts on the prosecution's evaluation that the stabbing occurred during a struggle?
It simply doesn't add up. According to the autopsy report, the knife entered the body of the victim at a slight downward facing angle with the blade facing up. Now, this would be consistent with the assailant stabbing and applying a great amount of force in a downward facing angle. And it would not be consistent with the two being involved in a struggle. If the two were involved in a struggle, in order for the knife to enter the body at this way, the assailant would have needed to apply a great amount of force in order to go through the scapula and puncture the aorta. In order for the assailant to needed to apply a great amount of force, they would have needed to be larger than Mr. Brackman. And the person shown on the Ring doorbell videos does not fit this description.
Well then, in your expert opinion, how did the stabbing actually take place?
In my expert opinion, I believe that the stabbing took place as a surprise attack from behind, in which the victim was in a seated position and the assailant surprised the victim, stabbing them from behind.
And why does this matter to the case?
Well, it matters because a surprise attack from behind is very different than a simple break-in. You see, it suggests something much more sinister.
And did you get a chance to review the Ring doorbell evidence in this case?
I did, yes.
What are your thoughts on the prosecution's analysis of that?
Well, the prosecution never verified.
I'm sorry, Ms. Humber.
Best evidence. I have an objection to best evidence. This witness has not entered these exhibits into evidence.
Mr. Anderson?
Your Honor, I believe it should be Exhibit 10 was already entered into evidence, and she is not testifying as to what is pictured in the video, but as to circumstances surrounding the notifications in that video.
I'll overrule the objection. Thank you.
Professor, would you like me to re-ask the question?
Yes, please.
What are your thoughts on the prosecution's analysis of this doorbell evidence?
Well, the prosecution never verified that Mr. Brackman had his push notifications on. You see, it is very easy to turn your notifications off. And so the idea that the victim was alerted by Ring doorbell has no evidence to support it. It is very likely these notifications weren't on. And even if they were on, that doesn't mean that Mr. Brackman saw them.
Professor, were you made aware of the text message screenshots in this case?
Yes, I was.
And what is your analysis of the handling of that evidence?
These screenshots were never verified. You see, from my time on the Aurora Police Department, I know that the Denver police use a technology called Cellbrite, which makes it very easy for them to download the context of a user's phone. And in this case, they did not do that. They never downloaded the contacts of Ms. Fuentes' phone to verify that these screenshots were real. And therefore, we have no way to know for certain if they are real. There are many ways in which screenshots can be altered, faked, or doctored, and so we cannot trust this piece of evidence.
And Professor Van Owen, were you given access to the cell tower reports collected by the police in this case?
Yes, I was.
And I believe Exhibit 16 has already been entered. If co-counsel could please pull that up.
I'm sorry, which exhibit?
16. Did you take any issue with the prosecution's analysis of this cell tower evidence?
Yes, I do. I believe that the prosecution is trying to pass off cell tower data for GPS data, in which case it is not. You see, there are many factors that go into determining which cell tower a phone may connect with, geographical factors, weather, usage, many factors. And a phone can connect with a cell tower up to 38 miles away. Therefore, the fact that Ms. Becker's phone contacted a cell tower near Mr. Brackman's house does not show that Ms. Becker's phone was at Mr. Brackman's house.
And why is this important to the case?
Well, this is important because it just goes to show the many assumptions made by the prosecution. You see, the collection of this data was very one-sided. The prosecution only subpoenaed records for the cell tower data on the afternoon of the murder, not the morning of or night before, in order to verify Ms. Becker's alibi. Also, they only looked into one suspect, which is very one-sided.
If co-counsel could take down the exhibit. Speaking of suspects, Professor, did you form any opinions on any alternate suspects in this case?
Yes, I did.
And who might that be?
Well, upon my investigation, I came upon a much more likely suspect, a Mr. Blair Rollins. Blair's father was represented by Mr. Brackman a couple months before the murder and unfortunately was put away for a life in prison. Blair witnessed these court proceedings and even testified at his father's trial. And in my expert opinion, I believe that watching your father be put away for a life in prison is a much greater motive than getting kicked off a mock trial team.
And did Blair Rollins have any connections to any other suspects in this case?
Yes, upon my investigation, I found out that Blair Rollins was friends with Mrs. Fuentes and also in contacting members of school people at Colorado High School, I found out that Blair Rollins had a similar height and build to the person on the Ring doorbell videos.
Is there anything that stood out to you about the police's investigation of this suspect?
Yes, even though the evidence points towards Blair Rollins as a much likely suspect with a much greater motive, the police never thought to look into Mr. Rollins as a suspect and simply failed to consider any other options.
So after discovering all the evidence that you previously talked about, what conclusions about the case as a whole did you come to?
Well, first of all, the stabbing did not occur in the way that you might be led to believe. In fact, it was a surprise attack from behind, which suggests something much more sinister than a simple break-in. Secondly, the cell tower data is not as accurate as it may seem and does not place Ms. Becker's phone at Mr. Brackman's house on the date of the murder. The screenshots were never verified. The notifications were never checked. And other suspects with much greater motives were never looked into. Due to it is the rushed nature of this investigation and the false assumptions made by the prosecution that have put Ms. Becker in this bad dream here today.
Thank you, Professor Van Owens. No further questions at this time, Your Honor.
Mr. Anderson, thank you. Ms. Humber, if you'd like to cross-examine, please.
Yes, Your Honor. Permission to proceed?
Sure.
Good morning, Ms. Van Owen. I'd like to start by clarifying something you said on direct. You said that cell towers can cover up to 38 miles.
First of all, I prefer to be addressed as Professor Van Owen,
My
and yes,
apologies.
it's okay. And yes, they can cover up to 38 miles, even 100 miles in some cases.
Professor, if I could direct you to a line I have here in your affidavit. In some rural areas, a single cell tower might cover over 100 miles. In urban areas, towers are more tightly packed, but each one can still cover up to a 6 or 7 mile radius.
Yes, I also mentioned in my expert report that they can cover around 38 miles. And in this case, that is the most likely area that a cell tower may cover.
I see. And Professor Van Owen, have you entered your report in today's trial?
No, but it is a part of evidence and I did it upon my investigation. Also, 38 miles falls in between 6 and 100, so it's a very wide span of mileage that a cell tower can cover.
Professor Van Owen, the statement where you say 38 miles has not been entered into evidence, correct?
I do not believe so, no.
All right. I'd like to transition to your career as an investigator, specifically payment. You charge $225 per hour for investigation work?
Yes, I am charged for my work just as the prosecution's expert witnesses are.
Yet you charge $450 per hour for court testimony?
Yes, I do.
Your payment doubles just by stepping in the courtroom?
However, it does not affect the way in which I conduct my investigations. I try my best. Oh, sorry.
That wasn't quite my question. Your payment doubles just by stepping in a courtroom from $225 to $450.
Objection, Your Honor, asked and answered.
Overruled. You can answer that.
It does, but in no way affects my testimony.
Is that because in a courtroom, you're under the penalty of perjury?
I'm sorry, that's not in my witness statement. Would you like me to answer?
No need. Let's talk more about the actual work you're getting paid for. You've consulted for over 100 cases?
Yes, I have.
And on estimate, how many of those have been for the defense?
All of them, as that is common in my field as a private investigator.
You've never testified against the defendant?
No, the prosecution doesn't really hire private investigators.
Out of 100 cases, you have always taken the defendant's side.
As I mentioned, it's common in my field.
With that, let's talk about the facts at hand. You disagree with the prosecution's theory that there was a struggle during the crime?
Yes, I do.
You believe that ring alerts and scuff marks are unreliable indicators of a brawl?
Yes, the ring notifications were never verified and the scuff marks cannot be carbon dated.
Now, you are the defense's expert in analyzing police evidence, correct?
Yes.
And you heard both prosecution experts testify to a broken plate on the scene?
I did, yes.
And yet, the broken plate is left out entirely from your analysis?
There are many ways in which this plate could have been broken, and I didn't see need to mention it in my analysis.
Thank you. I'd like to transition to a different aspect of your story, specifically the alibi. It is your belief that Mr. Perkins and the defendant were together during the time of the murder?
Yes, and this is consistent with the evidence put forth.
That they were out looking for the defendant's phone?
Yes, that is why they were both absent from school on March 26th.
You believe that Mr. Perkins was sending texts to the missing phone?
Yes.
And cell tower records of Mr. Perkins' phone could confirm this theory?
They could. Unfortunately, the prosecution failed to obtain these records.
In fact, you believe the evidence could prove the defendant's alibi?
Well, I believe that cell tower analysis isn't as precise as one may be led to believe. It would be a factor in confirming the defendant's alibi, so it could have, yes.
Okay, and you had the ability to obtain these records from Mr. Perkins' phone?
I did. However, my job is simply to investigate the work done by the prosecution.
You had the ability to obtain the records?
Objection, Your Honor, asked and answered.
Overruled.
I believe so, yes. But once again, it falls on the prosecution to do so.
So you had the ability to receive them and didn't bother to present it to the jury?
Yes, as it is the prosecution's job.
Interesting. While we're on the topic, let's talk more about cell tower records you did decide to look at. Could I direct you to Exhibit 16?
Of course.
Now, you stated that these records are, oh, sorry, do you have this exhibit pulled up?
I have it in front of me, yes.
You've stated that these records are inconclusive of the defendant's phone's location.
Yes.
You claim that cell towers jump from tower to tower.
Yes, they can connect with towers miles away.
If you could confirm with a yes after each statement, I'm going to read the time and location of each record on this map.
Okay.
1247, cell tower near the defendant's house.
And Mr. Rollins' house, yes.
1255, cell tower near a major intersection.
Yes.
105, 106, 117, cell tower near the victim's house.
Yes.
Were those times all in chronological order?
Yes.
And you believe this chronology is due to coincidence alone?
I believe that cell tower data is not very accurate, and yes, it is a coincidence. Also, these this exhibit
That wasn't
shows.
quite my question. Oh, you answered my question. Thank you, Professor Van Owen. Your Honor, no further questions at this time.
All right, Mr. Anderson, do you have redirect for the professor?
Yes, Your Honor, a brief redirect. Professor, what are you paid for in your investigation?
I am paid to conduct my investigations in a just and fair manner, and that is all.
Now, Ms. Humber brought up the broken plate on cross-examination. What exactly are your opinions surrounding that broken plate?
I believe there are many ways that this plate could have been broken, and when the victim got up after being stabbed, the plate could have been broken in this way, so it does not indicate a struggle.
And what exactly makes you question the cell tower analysis?
Well, cell tower analysis is not as accurate as you may believe, as I keep mentioning. Also, the path that Ms. Hummer showed on cross is consistent with Mr. Rollins taking the phone to Mr. Brackman's house. So, yeah.
Thank you, Professor. No further questions, Your Honor.
All right, thank you, Mr. Anderson. Ms. Humber, anything else for the Professor Van Owen?
No, Your Honor.
All right, Professor, thank you. You can step down. Thank you.
Thank you, Your Honor.
Sure. And if the defense would like to call its next witness, please.
Yes, Your Honor. The defense would like to call Taylor Perkins to the stand.
All right. Ms. Perkins, good morning. You've previously been sworn. Ms. Dieter, go ahead.
Good morning, Mr. Perkins. My name's Caroline Dieter, and I'm going to be asking you some questions today. If you could state your name and spell your last for the record.
Yes, my name is Taylor Perkins. That's Perkins. My student name is Macklin Gifford.
Thank you. Mr. Perkins, where do you currently go to school?
Right now, I'm a freshman at CU Boulder.
And before that, what high school did you attend?
Well, last year I graduated from Colorado High School.
And in your time there, did you participate in any extracurricular activities?
Yeah, I was a member of the mock trial team for almost 4 years.
And were you close with any of your teammates?
Yeah, Avery Becker's my best friend, was for all of high school.
And Mr. Perkins, you say that you are close with Miss Becker. Is it hard seeing her in this position here today?
Yeah, it really is, especially because I know for a fact that she didn't do it.
I see. And could you please tell me who you and Miss Becker's mock trial coach is?
His name was Mackenzie Brackman.
And how did you feel about him?
I didn't have the best relationship with Coach Brackman, given how he treated Avery, but again, that was largely because of how he treated her.
Knowing that, how did it appear he and Avery got along?
They had a worse relationship than I did, the kind you'd expect to have with a teacher who loves to single you out in front of the entire class.
I see. Mr. Perkins, I'd like to talk about the day before the murder. Could you tell me what you were doing that night?
The night before the murder, we were at the Fry Shack, and then we went to the mall.
And while you were at the Fry Shack, did you see anyone you knew?
Yeah, we saw Alex Cifuentes.
And did you speak? Actually, I should ask. You mentioned Alex. Could you please tell us who that is?
Yeah, Alex was another member of the mock trial team last year. She also went to CHS with us.
And being on the same team, could you tell me how Alex and Avery's relationship appeared?
Well, they appeared decent on the outside, but deep down you could tell that they didn't really get along.
How do you mean?
Well, Alex was really good at being completely insincere and passive aggressive and could really get under Avery's skin.
Objection, Your Honor, speculation.
Your response, counsel?
Being that the witness has been on the team with both of these people for several years, and in addition, he's also a close friend of Miss Becker, he would be able to form a logical conclusion as to what about Mr. Cifuentes, Mrs. Cifuentes annoyed her.
Objections overruled. Thank you.
Would you like me to re-ask that again, Mr. Perkins?
Yes, please.
Being that you were on the same team as both Mr. Cifuentes and Alex, what exactly about their relationship seemed that they didn't get along?
Well, Alex was really good at being passive aggressive, could be totally insincere, and most people couldn't tell, but it was clear that she got under Avery's skin.
I see. And did you speak to Alex that night?
Yes, we did. She came over to the table with us.
And during the course of that conversation, did anything happen?
Yeah, Avery got up and went to the bathroom.
Was this unusual?
Yeah, it was pretty unusual, especially because she left her phone on the table, which she never does.
And why is that unusual to you, Mr. Perkins?
Avery always has her phone with her. I mean, unless she's sleeping or something, which I can assume she isn't holding her phone. But other than that, it's always within reach.
And do you believe that anything specific caused her to leave her phone behind?
She seemed pretty flustered. If anything, it would have been that.
Why was she flustered?
Objection, Your Honor, calls for speculation.
Counsel?
Once again, Your Honor, knowing Miss Becker very well and for several years, Mr. Perkins would be able to draw a logical conclusion based on his perception of the situation at the time as to why she might have been upset.
Objection overruled.
Would you like me to ask that again?
Yes, please.
Why do you believe that Miss Becker was upset?
She seemed pretty flustered because she had been just sitting there. We were fine. And then Alex came over, was being pretty passive aggressive, and Avery clearly didn't want to take it. So she went to the bathroom.
And did she come back?
Yes, she did.
What did you do after she came back?
We left fairly quickly. Neither of us really wanted to be there any longer than we absolutely had to.
Okay. Mr. Perkins, let's talk about the next morning, the day of the murder. Could you tell me what the first thing you did that morning was?
Well, the first thing I did that morning was I was texting and calling Avery repeatedly, but she wasn't responding to anything.
And what happened next?
Well, she came by my house and picked me up for school, but then I pointed out that she wasn't responding to anything, and we realized since neither of us knew where the phone was, it was truly missing. So we skipped school and went to go look for it.
Where did you look for it?
Well, we started off at the mall because we had been there more recently, and then we went to the Fry Shack after we couldn't find it.
When you were looking in the mall, did you take any extra steps to aid you in possibly finding Miss Becker's phone?
Yeah, we were texting it and calling it repeatedly, but no luck.
And you said that you looked in the Fry Shack. Did you find it there?
No.
And after you failed to find it at the Fry Shack, what did you do?
Well, we just stayed at the Fry Shack for a little while. We'd been going around all day looking for the phone. We just felt like sitting down and resting for a bit.
And while you were at the Fry Shack a second time, did you see anyone you knew then?
Yeah, we saw most of the mock trial team, actually. They showed up to the Fry Shack and said that Coach Brackman hadn't come to practice that day.
Did anything about that feel unusual or stand out to you?
Well, not at the moment. It could have been anything, but later on we found out that he had died. It was pretty eerie thinking that we were talking about him while he was either being killed or dead.
I see. And were you with Miss Becker all the time leading up to that point?
Yes, the entire day.
Your Honor, may my co-counsel display Exhibit 16, which has been previously entered?
Sure.
Mr. Perkins, could you please show us where Mr. Brackman's house is on this map?
Yeah, there's a pin at the bottom of the map that says Brackman's house.
And could you show us where the fry shack was?
Yeah, the fry shack is all the way on the right side of the map. There's a little yellow icon that says mall, and the fry shack is just below it.
Now, do you see the dotted line that indicates the perpetrator's assumed path?
Yes, I do.
Could you show us where that path falls in relation to the fry shack where you and Miss Becker were?
Yeah, the path is in the middle of the map, but we were over on the right side of the map, like I said. We were nowhere near this path.
I see. May my co-counsel please remove the exhibit? Mr. Perkins, I'm sorry to ask, but it's necessary that we know this. Are you willing to lie in Miss Becker's defense?
Absolutely not. Our friendship is founded off of truth, and we wouldn't violate that, especially now. A man is dead. That's no place to joke around or lie.
Finally, Mr. Perkins, do you believe that it was at all possible for Miss Becker to have been involved in Mr. Mackenzie Brackman's death?
Absolutely not. I was with her the entire day leading up to when we went to the fry shack, and we were nowhere near his house.
Thank you, Mr. Perkins. No further questions, Your Honor.
Ms. Dieter, thank you. Ms. May, if you'd like to cross-examine.
Thank you, Your Honor. Good morning, Mr. Perkins. If you could please keep your answers to a yes or no, that would be great.
I'll do my best, Counselor.
You've known Avery for a long time, correct?
Yeah, she's my best friend of all
You're
of high school.
incredibly close with Miss
Yes,
Becker.
like I said, she was my best friend.
You joined mock trial just because of Miss Becker.
Yes, if it weren't for her, I wouldn't have wanted to try out.
And then you proceeded to quit because of Miss Becker.
It mattered more to her to be on
Yes
mock
or no?
trial.
Did you quit to benefit Miss Becker?
May I finish my answer?
It's a simple yes or no would be sufficient. I'm asking if you quit.
Yes, I quit to let Avery back on mock trial.
Okay, so you're a very loyal friend.
Yes, I'm her best friend.
Throughout the time you spent at mock trial, you observed the relationship between Mr. Brackman and Miss Becker, correct?
Yes, they knew each other. They had a... Sorry, what?
You observed their tension?
Yes, everyone did.
You observed their fighting?
Yes.
After Avery was kicked off the team, you guys discussed ways to get her back on the team, correct?
Objection, Your Honor. Hearsay.
Ms. May?
Your Honor, this is not a statement made to go to the truth of the matter asserted, rather for the effect on the listener in this case being Ms. Perkins when Ms. Becker was asking her for help to get back on the team.
Objection overruled. Thank you.
I'll repeat my question. After Ms. Becker was kicked off the team, you discussed different ways to get back on the team?
Yes, we did.
And some of those ways included the entire team texting the entire team to come up with ways to get back on.
Yeah, she texted pretty much everyone, as far as I know.
You texted Ms. Alex Fuentes?
I can't say if she did or not. I wasn't in the text thing. I think she did, but I can't tell you.
Everyone on the team would include Ms. Alex Fuentes.
I'm sorry, you cut out. Can you repeat the question?
In your statement, you did say she texted everyone on the team. Everyone on the team would include Ms. Alex Fuentes.
I said she texted everyone on the team as a figure of speech because she pretty much texted everyone on the team. I said I think she even texted Alex Fuentes, but I never said for sure.
But you did say everyone on the team, yes or no?
I did say everyone on the team, but it's a figure of speech, Counselor.
I'm not asking if it was a figure of speech. Mr. Perkins, did you observe the relationship between Ms. Becker and Ms. Fuentes throughout your time at mock trial?
Yes, I did.
They seem to be good friends?
Not to me.
Yet, in saying she texted everyone on the team, that would include Alex, so she texted someone who wasn't her friend in an effort to get back on the team.
Like I said, I can't confirm if she texted Alex.
Were you at school the day that Mr. Brackman was killed?
No, I was with Avery at the Fry Shack and Mall, like I said before.
You were looking for Avery's phone all day?
Yes, we were.
You called and texted Avery's phone while looking for it?
Like I said, yes, we did.
Yet throughout the entire day you spent looking for it, you only called it 5 times.
I don't remember the exact number off the top of my head, Counselor, but I do remember that we were calling and texting the phone repeatedly.
Yes, your statement says you did call 5 times.
Well, then,
Throughout that time, you did not think to use Find My iPhone.
no, we did not. I have an Android, and we didn't think to use the iCloud website.
You stated in your statement that you were nowhere near Mr. Brackman's house, correct?
Correct. We were at the Fry Shack and Mall.
So you know where Mr. Brackman lives.
On the map, it has a pin that
You
says.
did not see that map prior to testifying here today. You saw that map after it was admitted into evidence. You had no prior knowledge of this map.
Objection, Your Honor.
What's the objection, counsel?
The opposing counsel is implying that the witness wouldn't, in fact, have the knowledge, but the map was labeled and previously entered, so I'm not sure how this line of questioning is admissible.
Permission to respond.
Ms. May?
Your Honor, the witness did not see this map prior to testifying here today, and in his affidavit, he did state that they were nowhere near Mr. Brackman's house, indicating that prior to seeing the map, he would have known where Mr. Brackman's house was.
May I respond?
Sure, Ms. Dieter, go ahead.
Seeing as this was previously entered, he would have in fact seen it and seen the label indicating Mr. Brackman's house. So I do not feel that it would imply that he knew previously where Mr. Brackman lived.
I'll overrule the objection. Thank you.
Thank you. I'm going to re-ask the question. You stated in your affidavit that you were nowhere near Mr. Brackman's house.
Yes, that is what I said in my affidavit.
So prior to seeing the map that was previously shown to you on your direct examination, you had knowledge of where Mr. Brackman lived.
I was told by Avery's lawyers that the map was, well, I have seen the map many times, not the exact map.
I'm not asking about the map. I'm asking about.
Objection, Your Honor. Badgering the witness. She's hardly letting him finish any of his answers.
I'm going to overrule the objection, but Ms. May, would you restate the question or repeat the question?
Yes. Mr. Perkins, I'm simply asking, prior to seeing the map that was provided here today, which you did not see prior to testifying due to the fact that this map was not involved in your affidavit, you knew where Mr. Brackman lived.
I was informed by her attorneys of where it was. Generally, not the exact location or address, but I did know that it was generally on the lower area of where that map was. I've seen the general map many times because I live in the area.
Okay, thank you. Prior to testifying here today, you spoke to Avery after Mr. Brackman's death.
Yes, correct.
Objection, Your Honor. Hearsay.
Overruled.
And during this conversation, Ms. Becker brought up the idea that Mr. Blair Rollins may be involved.
Yes, correct. She did.
So the defendant in this case, the only suspect on trial today, introduced the idea into your head that someone else could have committed this murder.
Her
Yes
and
or no?
attorneys introduced the idea to my head, correct.
Thank you. No further questions, Your Honor.
All right. Ms. Dieter, cross-examination.
I do have a brief redirect.
Or I'm sorry, redirect, Ms. Dieter.
Mr. Perkins, is mock trial that important to you?
Well, it's fairly important to me, but only if Avery's on the team. If she's not on it, it's not very fun for me.
So it wouldn't be that big of a sacrifice for you to step down, correct?
If she's not on the team, it wouldn't be much of a sacrifice at all.
Thank you, Your Honor. No further questions.
Ms. May, anything else for Mr. Perkins?
Permission to recross.
Sure.
Mr. Perkins, you did step down from the mock trial team in order to benefit Ms. Becker, correct?
As I've said many times, yes, I did.
Thank you. No further questions.
Ms. Dieter, anything else for this witness?
Oh, I thought I was muting. No, Your Honor.
Okay. Mr. Perkins, thank you. You can step down.
Thank you, Your Honor.
And if the defense would like to call their next witness, please.
Your Honor, the defense calls Miss Avery Becker to the stand.
Ms. Graham, thank you.
Good afternoon, Miss Becker. My name is Kira Graham, and I will be asking you some questions. Miss Becker, I'm sorry, before we begin, can we please get a quick time check? Thank you, Mr. Howe. Miss Becker, did you go to high school?
Yes, I attended Colorado High School.
And while you went to Colorado High School, did you do any extracurriculars?
All 4 years I was there, I was part of the mock trial club.
And in mock trial, do you have coaches?
Yes, we do.
What was your coach's name, Ms. Becker?
My coach was Mr. Brackman.
And how did you and Mr. Brackman get along?
We really didn't. We often fought.
I'm sorry, what do you mean by you fought?
Not physically, of course. I would never physically hurt someone, but verbally we'd get into it with each other at almost every practice.
And why were you and Mr. Brackman always verbally arguing?
It seemed a difference of opinions. He always said that he never liked my way of preparing for things.
Thank you, Ms. Becker. Let's talk about your last few days on the team. Can you recall when the last game you went to was?
It was the meeting right after regionals.
And at that meeting, did you and Coach Brackman argue?
Yes, it was the worst fight we had ever gotten into.
What did he specifically say to you?
He basically said that, so at regionals, I won Best Attorney Award and Best Closing, and he said that I didn't deserve it.
Did you do anything in retaliation to his comments?
Yes, and it's really embarrassing. I was so frustrated that I stormed out of the classroom with what I thought to be an expo marker and wrote Worst Attorney Award on his Porsche.
What do you mean by what you thought was an expo marker?
Well, later I found out that it was actually a permanent marker, a Sharpie.
And Ms. Becker, can you recall how Mr. Brackman reacted to seeing what you had done to his car?
He was infuriated, and he immediately kicked me off the mock trial team for good.
Did you try and apologize to him for what you had done?
Absolutely. I felt awful about it. I tried to apologize in person, but his secretary said he wouldn't see me. And then I even offered to scrub off the permanent marker and then get a summer job to pay for repainting of his car.
Thank you, Ms. Becker. Let's talk about the day Mr. Brackman passed away. Can you recall where you were the night before?
The night before, I was at the Fry Shack and then the mall.
And did you go anywhere else that night?
No, just home.
Who were you with the night before Mr. Brackman passed away?
I was with Taylor Perkins.
And did you run into anyone that you knew along the way?
Yes, while at the Fry Shack, we ran into Alex Cifuentes.
Thank you, Ms. Becker. Let's move on to the next morning. Can you tell us briefly what happened the next morning?
The next morning, I remember waking up from a dream into what seemed like a nightmare. My phone was missing, so I went over to Taylor's and we decided to skip school to go looking for it. And then later we found out that Coach Brackman had been killed.
And were you with Taylor Perkins all day?
Yes, all day.
And you said your phone was missing. Did you do anything specifically to try and find it?
Yes, we tried to call it and text it.
Did any of the calls go through?
No, they didn't.
Were you able to discern anything from the fact that the calls did not go through?
We were able to figure out that it was either dead or stolen.
Thank you, Ms. Becker. Let's talk about someone who might know now. Have you heard of a person named Blair Rollins?
Yes, she attended CHS for 3 years while I was there.
And have you met Blair Rollins?
We ran into each other a couple of times in the hallways, yeah.
And do you know if she was friends with anyone you knew?
She seemed to be pretty good friends with Alex Cifuentes.
Objection.
To the objection, counsel.
Lack of personal knowledge, no foundation. Actually, lack of foundation because no foundation has been laid as to this witness's knowledge of that relationship.
Counsel, your response?
Your Honor, we just set foundation that she knew Ms. Blair Rollins and that she has met her personally. And as she was about to say, the person that Blair Rollins was actually friends with was on the mock trial team. So we were setting up foundation in the answer Ms. Becker was just giving.
Okay, overruled. Thank you.
Ms. Becker, please continue.
Could you repeat the question? I'm sorry.
Yes. Were you aware if anyone you knew?
Yes, she seemed, like I said earlier, she seemed to be really good friends with Alex Cifuentes.
And were you friends with Alex Fuentes?
No, we've never really gotten along, so I honestly have no idea why she always says that we're best friends.
And you said previously that you've met Blair Rollins. Can you recall what she looks like?
She looks really similar to me. We have the same height, a really similar build, and even the same hair color.
Thank you, Ms. Becker. Now, can my co-counsel please pull up Exhibit 14?
I have it in front of me.
Oh, okay. Ms. Becker, are you aware that Alex de Fuentes is claiming that you sent these messages to her?
I'm aware of the claim, but I would never send these messages.
Thank you, Ms. Becker. Can co-counsel please take down Exhibit 14? Ms. Becker, we know you and Mr. Brackman were always arguing. Did you ever get mad enough to want to physically hurt him?
Never. I'm not a physically violent person, and no matter what our disagreements may be, I would never want to hurt him.
And finally, Ms. Becker, did you in fact kill Mr. Brackman?
No, I didn't.
No further questions, Your Honor.
Counsel, thank you very much. Cross-examination. Ms. Seneschal.
Yes, Your Honor. Before I begin, could I get a time check?
Sure.
Thank you, Ms. Bennett Spurlock. Good morning, Ms. Becker. Mock trial came naturally to you, right?
Could you get closer to a mic? I can't hear you. I'm sorry.
Yes, Your Honor, could we pause the time while I put in headphones?
Sure.
I'm so sorry.
Not at all.
Is that better, Ms. Becker?
Yes.
Okay. My first question was, mock trial came naturally to you, right?
Yeah, I'd say.
But despite your talent, Brockman criticized your work, right?
Yes, he never seemed to like the way that I prepared for things. It was always his way or the highway.
So that's a yes.
Yes.
And Mr. Brockman demoted you from A team to B team?
Yes, he did.
And after being demoted, you said that you did everything you could to convince Brockman.
I'm sorry, what was the objection?
Objection to hearsay, Your Honor.
Your response, Ms. Seneschal.
Yes, Your Honor. This is a statement made by the witness on the stand, and it is in her own affidavit.
All right.
Mayor,
Go ahead, Ms. Graham.
even though it is in her affidavit, that is still an out-of-court statement, and she did not testify it here today, so I do not know why the opposing counsel brought it up.
I'm not sure I heard the entire question. Ms. Seneschal, would you repeat the question or state the question you intend to ask?
Yes, of course. I said, after being demoted to B team, you said you did everything you could to convince Brockman to put you back on the A team.
Overruled. Thank you, Ms. Graham. And you
Ms.
can
Becker,
answer.
did you hear that question?
Could you repeat it one more time? Sorry.
Of course. After you were demoted to B team, you said that you did everything you could to convince Brockman to put you back on the A team, right?
Yes, just about everything.
And that's because mock trial meant everything to you, right?
Yes, ever since I started my freshman year, it meant so much to me. It became one of my passions.
Thank you. Thank you, Ms. Becker. At the mock trial tournament, you said you won the Best Attorney Award, right?
And best closer.
That's awesome. But Brockman continued to criticize your work, didn't he?
Yes, he did. I thought that he'd be proud of me for doing it, but he just continued the criticism.
And that made you really angry.
It did, yes.
In fact, you called him the worst coach in the state.
Could you repeat the first half of the question?
In fact, you called Brockman the worst coach in the state.
I did, yes.
And at the same practice, you were so angry that you stormed out of the room. Is that right?
I did do that, yes.
And then you took a giant permanent marker and wrote in giant letters across the hood of his Porsche, Worst Attorney Award. Is that right, Ms. Becker?
I wouldn't say it was a giant permanent marker, but I
permanent marker
thought to be an expo marker and wrote Worst Attorney Award.
Thank you, Ms. Becker. So you damaged Mackenzie Brockman's private property.
I did, and I'm really embarrassed and I feel awful about it.
Thank you, Ms. Becker. After you damaged his private property, he did not press charges, did he?
No, he didn't.
And Ms. Becker, that's because he was murdered before he could press charges. Is that right?
No.
Ms. Becker, you damaged his private property, and then after that, Mr. Brockman was murdered. Is that right?
Yes, he did die, but he could have pressed charges before.
Thank you, Ms. Becker. After Mr. Brockman saw what you had done to his private property, he kicked you off the mock trial team. Is that right?
He did.
And that made you even angrier.
It did.
So you went home and you had a conversation with your mom about the incident. Is that correct?
Where she told me to calm down, and I took the advice and realized the only thing I could do.
Is that a yes, Ms. Becker? Did you have this conversation?
Yes, I had a conversation with my
Thank
mom.
you.
Where she told me to calm down.
During this conversation.
Objection here today.
Counsel, will you complete the question first? I'll hear the objection in a second.
Yes, Your Honor. My question is, during this conversation, you told your mom that you would get back at Brockman if it was the last thing you did.
Okay, the objection's overruled. Thank you.
Ms. Becker, could you answer that question? Is that right? Is that what you said?
I did say that, yes.
Thank you, Ms. Becker. Moving on. After you vandalized the car, Brockman refused to talk to you. Isn't that right?
That's correct, even though I tried to reach out to apologize.
And this upset you, didn't it?
I mean, a little. I really wanted
You said that it devastated you. Didn't you say this, Ms. Becker?
I did.
And you heard your teammate, Alex Cifuentes, testify in court today, right?
I did.
Ms. Cifuentes testified that you texted her shortly after being kicked off of the mock trial team. She testified that you texted her, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. You heard that, right, Ms. Becker?
I heard the testimony, but I never sent those texts.
Thank you, Ms. Becker. Ms. Cifuentes also testified that you then texted her, I'm going to wait until he's at work, then break in and trash his house. Did you hear that, Ms. Becker?
Once again, I never sent those texts, but she did testify.
That's right. You deny sending the text, don't you?
Because I didn't send them.
Well, you deny sending them because you testified today that you allegedly lost your phone on the day of the murder. Is that right?
My phone had gone missing the night before.
Thank you, Ms. Becker.
It was missing the day of.
You claim that you were with your teammate, friend, Taylor Perkins on the day of the murder. Is that right?
I was with Taylor all day looking for my phone.
Yes, all day, right?
All day.
And if you needed anything, you would go to Mr. Perkins, wouldn't you?
I did not hear the first part of the question. Could you repeat it?
Yes, my apologies, Ms. Becker. You said that if you needed anything, ever, you would go to Mr. Perkins. Is that correct?
Yes.
And let me just get this straight. Mr. Perkins is the only one who can confirm your alibi today.
Yes, he is.
And you spoke to Mr. Perkins after the murder, but before today's trial. Is that right?
Yes, we have been speaking.
And you were the one who introduced the idea that Blair Rollins could somehow be involved in this crime to Mr. Perkins. Is that right?
I just thought that it's more probable that Blair, who actually had an
Is that a yes, Miss Becker?
yes.
Miss Becker, you were not at school on the day of the murder, were you?
Once again, I was out looking for my phone.
Thank you. Your Honor, I just need to consult with my co-counsel super quickly.
Okay.
No further questions. Thank you, Miss Becker.
Counsel, thank you. Any brief redirect for this witness?
Perhaps, Your Honor. First, can I find out exactly how much time I have left? Thank you.
So a couple of questions.
Miss Becker, you told your mom that you would do whatever it takes to get back at Mr. Brackman. The next morning, did you do that?
No, because after I calmed down, as my mom told me to do, I realized that I needed to apologize. It's the only right thing.
No further questions, Your Honor.
Ms. Graham, thank you. Anything else, Ms. Seneshin, in light of that question?
Yes, Your Honor, just one question.
Sure.
Miss Becker, is it true that you made this statement?
What statement are you referring to?
You told your mom that you would get back at Brackman, Mackenzie Brackman, if it was the last thing you did.
I did make that statement, but
Thank you, Your Honor. No further questions. Thank you, Miss Becker.
All right. Thank you. Anything else from Ms. Becker?
No, Your Honor.
Ms. Becker, thank you. You can step down. Any further witnesses for the defense?
No, Your Honor, the defense rests.
All right. Anything else before we proceed to closing arguments?
Not for the prosecution, Your Honor.
Actually, let me ask Mr. Anderson.
Yeah, nothing for the defense either, Your Honor.
I'm going to ask just a point of order and rely on the teams here. I have a set of jury instructions somewhere, but my recollection is that it's not necessary for me to read those prior to your closing arguments. Has that been your practice in the first couple of rounds?
For the defense, yes, that's been the standard.
People agree?
Yes, Your Honor.
All right. If the people would like to make their closing argument then.
Yes, Your Honor. Permission to proceed?
Yes, Ms. Humber, go ahead.
Mischief was intended. In murder, it ended. Members of the jury, allow me to take you back to a scene that my co-counsel, Miss May, mentioned in her opening. It's 3 o'clock on a Thursday, and Avery Becker furiously storms into the kitchen. See, practice after practice, her mock trial coach has ridiculed her efforts. Coach Brackman's criticisms have gotten worse, and she's had enough. After Coach Brackman demoted and removed the defendant from the team, she boiled in rage, climbed to the top of his car, and wrote in bold permanent marker across the hood, "Worst Attorney Award." But to her, this wasn't enough. As she hides away the Sharpie, the defendant texts her friend Alex, telling her plan to break into Brackman's house and once again vandalize his belongings. Her eyes are tearful with anger. The defendant's mom enters the kitchen to ask what's wrong, to which the defendant responds, "I'll get back at him if it's the last thing I do." Today, the prosecution has proved beyond a reasonable doubt that the defendant committed second-degree burglary and first-degree murder. We have proven that the defendant knowingly and unlawfully entered the dwelling of Mackenzie Brackman with intent to cause criminal mischief. While in this dwelling, the evidence proves that the defendant during a burglary caused the death of Mackenzie Brackman. To break that down, mischief was intended, in murder it ended. The prosecution holds the burden of proving the defendant guilty beyond a reasonable doubt. Please remember that reasonable doubt is not based on possible or speculative doubt. Reasonable doubt must be based on the cumulative evidence presented. Looking at this case as a whole, the prosecution has left no reasonable doubt. The defendant demonstrated intent to break into Mackenzie Brackman's house. Alex C. Fuentes read the vengeful text wherein the defendant states, "I'm gonna wait until he's at work, then break in and trash his house. That'll show him." Less than 24 hours later, a person masked and gloved with the same height and build as the defendant is seen at Brackman's house. Detective Kyle Kuzak presented video evidence of this intruder as she's seen breaking in through the back door, just as the defendant said she would. Upon entering, the defendant came face to face with Mackenzie Brackman. A confrontation ensued. Brackman was stabbed, and the defendant fled the scene. Detective Jordan Markowitz testified to evidence of this struggle firsthand. A broken plate, a flipped chair, and Mackenzie Brackman dead on the floor from a fatal stab wound. During this time, Alex sat in class, Avery's empty seat beside her, and wondered why she wasn't in school that day. But members of the jury, you know where she was. Detective Markowitz testified to cell tower records placing the defendant's phone at Mackenzie Brackman's house the day and time of the murder. She drew a clear line of the path. I challenge opposing counsel to answer the question, where is the defense's line? What is the common thread? The prosecution has proven the answer to be quite simple. They don't have one. Today, we look back at Avery Becker in the kitchen, fired up after vandalizing her coach's car, planning her next move. But this time her attack is more permanent than a Sharpie. Mischief was intended, in murder it ended. Members of the jury, the defendant, while unlawfully entering Mackenzie Brackman's home, caused the death of Mackenzie Brackman. Find her guilty.
Ms. Humber, thank you. And if the defense would like to make its closing argument, please.
Yes, Your Honor, but before I proceed, may I request that once I hit 3 minutes remaining, that my time be read in 30-second increments?
I certainly have no objection as long as your timekeeper can accommodate that. I assume so.
Thank you, Mr. Howe. May I proceed?
Yes, Ms. Dieter, go ahead.
In an instant, Avery's dream turned into a nightmare crumbling down around her, leaving her to stand alone among the wreckage. The people she thought were going to help her pick up the pieces were the ones burying her deeper. No matter how hard she tries, how much proof she can give, she can't escape this nightmare. No one cares. The prosecution has the burden of proof here today, which means in order to convict Ms. Becker, they would have had to show you, beyond a reasonable doubt, not just one, but all of the elements involved with first-degree murder. Avery started her day off like any other. She drove to pick up her friend Taylor and take him to school. When these two friends realized Ms. Becker's phone was missing, they drove to the mall. After frantically texting and calling the phone with no success, Avery remembered the last place she had seen it. So she and Mr. Perkins took a walk to the fry shack. They wanted to check their table, the very same table that Miss Cifuentes sat down at and used Miss Becker's phone. The prosecution's entire case rides on one main thing. That thing is this missing phone that was last seen in Miss Cifuentes' hands. The prosecution expects you to convict Miss Becker based on their sloppy investigation. They corrupted important files beyond retrieval. They accepted an unauthenticated screenshot from an incredibly biased witness, hoping that she was what? Acting in good faith? This witness could testified incorrectly twice as to how long she has known Miss Becker and were expected to believe a character testimony from this Ms. Cifuentes? The prosecution could have retrieved Mr. Perkins' cell phone records to verify Avery's alibi, but they didn't. They could have followed up on the Blair Rollins lead, but they didn't. They could have done a lot of things, but they didn't. Why? Because they don't care. The prosecution is telling you here today that this was a murder of mischief intended and murder it ended. But the prosecution has yet to prove their one main point, the intent. They did not deem it necessary to prove that this intent was valid, and yet they still expect you to believe that. The prosecution, you heard from Professor Blake Van Owens that there was a far better suspect in this case. Kyle Kuzak herself indicates Blair Rollins as a suspect, suspect number 3. There was no physical or DNA evidence linking Miss Becker to this crime scene. The same cannot be said for Miss Rollins, however. Why? Because even as a suspect in this case, she was not investigated. She did not have to come down for an interview, submit DNA evidence, and she certainly did not have to prove an alibi as to her whereabouts on the day of the murder. The sad truth is that the prosecution has no real desire to come to find the truth in this case. Their desire is to come to the quickest conclusion here today and move on to their next case, even if it means convicting an innocent person. Ladies and gentlemen of the jury, we ask that you remember when you leave here today to make your decision that Miss Becker has shown through her own testimony and that of an eyewitness that she was at the mall during the crime. The prosecution has nothing tying her to the crime scene. That means that it would have been impossible for Miss Becker to have broken into Mackenzie Brackman's house, impossible for Miss Becker to have been the one with the intent to commit criminal mischief, and impossible for her to have been the one to ultimately kill him. Find Miss Becker not guilty. Wake her up from this nightmare. Thank you.
Ms. Dieter, thank you very much. And Ms. Humber, I think you have roughly a minute or so left for rebuttal.
Yes, Your Honor, permission to proceed?
Sure, go right ahead.
The defense attempted to offer the defendant's dream turned to a nightmare. With that, let me tell you the story of Mackenzie Brackman. Brackman is at the height of his career. He's succeeding as a criminal defense attorney and even finds time to teach future attorneys his craft. You could say he is living a dream. Yet one morning, as he's putting on his favorite mock trial t-shirt, he gets a notification of an intruder at the door. Moments later, he is fatally stabbed by his own mock trial student seeking revenge. Members of the jury, this is a nightmare, one that Mackenzie Brackman cannot wake up from. Mischief was intended, in murder it ended. Find the defendant guilty. Thank you.
All right, Ms. Humber, thank you very much. Anything else for either side then? Hearing nothing, the case will stand submitted then to our jury, Mr. Bockenstedt, Ms. Lindsay, and Ms. Rogers. I'm going to let you deliberate and score. And if you would, let me know, just unmute yourselves when you've completed the scoring, just so we know when it's complete. We'll have a brief critique after that. And I'm going to ask all the team members, at the risk of just overloading the bandwidth here, if you'll just turn on your cameras for a second so everyone can see you again. And while the scoring panelists are doing their thing, I can tell you that was just wonderful. I have a couple of comments that I'll keep to myself while the scores are working, but I can tell you that everybody undoubtedly watching this on YouTube is just going nuts now. They're storming out of the theater. They're hollering. They're applauding. It's wonderful job. Great job. What's really interesting to me And I think I said before, I, like all of you probably, and your families and everyone watching, have been living largely on Zoom for the last year. And I'll tell you, I've picked up a few tips from all of you. Number one, and what's really revelatory is how well this process works now that we're into it. You know, the concern has always been, now I mediate, which is a little more interactive than what you do as a judge on the bench. You know, and the concern initially was, gee, you don't have the same level of contact as you do with a party in the room across the table. That's just not true. That's just not true. In fact, in some ways, it's really enhanced. And I think your performance has all really kind of underlined that for me. Great job. Great job. And I appreciate your finesse with the technology as well. So again, great job. Do any of you have any questions for me in the moment? Okay. And are the scoring panelists still working? I think so.
Judge, I'm ready. I'm not
Okay.
sure if you need to be ready at the same time, but I can certainly start.
Why don't we wait just a second so that we don't influence anybody else's scoring? I don't think we would, but see, being a child of the 60s, I look at the screen and I can't get the Brady Bunch out of my head. The opening.
Would you believe that's the second time we've heard that reference?
Well, I think it's maybe age related. Mine as well as all of yours. And we may have lost Mr. Bockenstedt. Ms. Rogers, have you completed your scoring?
I have.
Great. So, Ms. Lindsay, if you'd like, and since Mr. Bockenstedt isn't here, I'm going to assume that he was able to get his score in okay. If not, he can take that up with the moderator.
Judge Miller, I'm sorry to interrupt.
Yeah.
I have Jennifer Rogers' score sheet, and that's it right now.
Okay, and you need Ms. Lindsay's?
So I need, yes, Miss Lindsay and Buckenstead.
Mr. Bockenstedt, I believe, has dropped off the meeting.
Oh, I'll call him. It's my husband. He's
I know.
Okay. So as soon as I get Miss Lindsay's, then
I have submitted it, so I'm not sure what the problem is.
sometimes it takes a minute because it goes through another system.
Okay. Great. Ms. Lindsay, do you have a couple of comments? Let's try to keep these to a minute or so, just keep everything logistically on track here.
I tried to list them because I had 8 pages of notes. That's how good this was. I am amazed. I mean,
yeah,
baffled at how good you guys all are, especially with how difficult I think doing it in this manner is. So bravo. I mean, all of you, the witnesses were amazing. Just everybody did a fantastic job. I'm going to just go down the line here. I thought Ms. Seneshan's cross was really, really well done of Becker. Great leading questions. So I wanted to point that out. Hearsay objections and responses, relying on the rule. You know who you are if you did that. To respond, I think that's critical. Relying on 801, whatever those are, really, really important. And you can plan that ahead of time. If you know you're going to ask about an out-of-court statement, have that ready to respond to, because Mr. Anderson is going to check on the hearsay objections. He is the man on that. So great job on those hearsay objections. Let's see, speculation. Ms. May, you caught a couple of those right up front. That was really, really great. I can't remember who referred to my defendant, somebody who represented the defendant, but be careful about that. That should be my client or Ms. Becker. You don't want to refer to your own client as defendant. Careful about showing disappointment or responding to rulings of the court when you're overruled. I'll just, Mr. Anderson, that was, I noticed that you were like, and I think you were mad at yourself and not the ruling, but poker faces are really hard to, are really needed in this format. So just be careful about that. And I am so guilty of that. So that's why I notice it when other people do it. So really quick, careful on, this was for many of you, interrupting witnesses' answers. That's a no-go, right? I mean, that I think I could have objected to argumentative a few times. You really want to let the witness finish that statement. Yeah, just interrupting, it just doesn't, the jury never likes it. You need to be doing that. Think about that. I know cross is hard. You start going for it and you're like, wait a minute, answer my question. But and it does take practice, but just be cognizant of that. It is argumentative, so you need to be really careful about that. Loved the openings, both openings. You knew them cold, both closings knew them cold. I love the looping of the themes throughout and then tying the closings back to that. It's succinct, and it just ties up everything, you know, from start to finish. I think that's most of it. But as I said, I'm like, oh my gosh. So it was just amazing. I'm blown away, truly. So great job.
Ms. Rogers. Ms. Lindsay, there's a note here that says you may want to hit submit again too. Ms. Rogers, go ahead.
You know, I would reiterate a lot of what was just said. You guys were fantastic. Everybody was so calm and so confident. And I was really surprised that I didn't see anybody reading notes. And I see that with practicing attorneys now. And I didn't, like I said, I was watching for it because I thought surely, especially on the opening and the closing, but y'all had it down pat. It was really good. It was very conversational. It was easy to follow. And I agree, the openings were fantastic. It felt like listening to a story, which was great. And I have a couple other notes. Well, my biggest note that I have in all caps is the professionalism that you guys showed in doing this was phenomenal. You had some difficult witnesses in there who weren't answering the way you wanted them to answer, I think, but you just maintained your composure, and it was really nice to see that. And that's huge when you're in court. So that was very impressive. And I had a couple that I pointed out. Ms. Humber, I thought your demeanor with the witnesses was phenomenal. You were very polite and accepting the answers and getting what you needed out of them. All of the witnesses were so good. I thought the closings were fantastic, the way you brought it back around and kind of felt like it all got tied up with a bow at the end. As far as the rules of evidence, the objections, fantastic. It was really impressive. I don't know what I was expecting. This is the first time I've done this, but it was not that. I did not expect you guys to be able to go through the rules and make objections, you know, standing on your feet with this stuff. It was really, really good. And you should all be extremely proud of yourself. And like I said, I'll end with the professionalism piece of it. That truly blew me away. You all were very professional with each other, with your witnesses, with opposing counsel, with the judge, and you can tell the time and effort you all put into this, and it was fantastic.
Absolutely.
I enjoyed my morning with you, so thank you very much.
Mr. Bockenstedt, do you have any comments for the teams?
Yeah, I'd like to congratulate everybody for doing such a great job. My interpretation of things, I don't have a legal background. I've got a typical jury background of coming from normal John Q. Public views. And I think you guys did great. And, I'm not a real fan of this Zoom thing, but that's the way we're going nowadays. I've done it in the past sitting in the courtroom, and in the courtroom, you get a whole different view of everything. And, I had done my scoring and writing down as we're going along. And then we get to the end and then like, oh boy, I got to go back and re-enter everything. So that's where I went to for a while there. But, I think you guys did great. I'm really proud of you guys for everything you've done, and just keep up the good work. And I thought the professionalism was very good today. So.
Thank you. I don't really have a whole lot to add. I just, the energy level was great. And again, it just fascinates me. It's a completely different vibe in many respects than you get in the courtroom. Not better, not actually in some ways maybe better. I've been doing this about as long as we've been doing the mock trials, I guess, a number of years. And I'll tell you, you two teams are as good as any I've seen. And I have no reason to think you couldn't compete very well at any level, state or national. I mean, it was just a terrific job. Like I say, the energy was great, very spontaneous on your part, which is always great. And I have to assume that that's a compliment to your coaches as well as your own abilities. So congratulations to your coaches and your families as well as each of you. Wonderful job. Wonderful job. Good luck. Be anxious to know how you did when the dust clears, okay? So we'll let you go now and get ready for the next round.
Thank you for
Thanks,
your
Darcy.
time.
Thank you so much, Your Honor. Thank you.
Thank you, everybody.
Thank you.
Great to see everybody. Thank you.
Arapahoe.org. No, it didn't submit for some reason. All right, I'm going to stay on until hopefully you guys get this. I'm going to try to email it. If you can hear me.
Mary Jo, great to see you. And
hi, Dia.
Yeah.
I'm oops, I got to turn my sound up. I can't hear you. I am asking one of the platform people to send me your score.
Oh, okay. I am trying to, I thought I saved it to my desktop to try to send it, but I'm not seeing it there. So I don't know what's going on.
So I've been doing mock trial for a while. I always thought that I didn't.
Can you turn that volume down, please?
All right, see if you can see this. Kim, I'm going to email this to you.
I practice law.
You just gotta turn it on. Okay, it's muted. He figured out how to do that.
Okay, I just emailed you, I think what.
I'm not getting scores for two people. They submitted, they both submitted. I'm telling Judge Madden because he said it's all in. He's looking at something. He said they should all be in. So I just let him know. I did not receive those two. And you know what? I haven't received. Oh, let's see. Okay, Dia, it looks like that worked.
Oh, good. I'm so glad.
Thank you so much.
I've got it. I think I've got it on my desktop if something goes wrong and you don't get it again. Let me know.
I've got it right here. Thank you so much.
All right,
I appreciate you.
You too.
Take care.
Okay. Bye.
You too. Bye-bye. Okay, courtroom 1 is done. So, but I still don't have Steve's, huh? Yeah.
Well, on First Simpson, practicing about 12 years, and good appeals. I did the other side, doing insurance companies. I used to do PI, but I don't do that anymore really, except for help out with trials a few times at First Simpson. I guess I serve on the Judicial Performance Commission, and I've been the chair for the last 2 years, and thank you so much.
Is your courtroom shut down?
Mr. Friedman, would you like
Pardon
to
me?
go next?
Is your courtroom shut down?
Sure. On the